Right? You wait for 2 weeks. After 2 weeks, you mention.
My lord, may I be permitted to mention one matter? Yesterday, a matter was mentioned by Advocate Devashish Saha. It was a Group 3 labor matter. Lordship allowed the mentioning, and it was supposed to come up today, but it has not come up in the list. Now, the urgency is we have been.
দেখি কেন আসেনি?
My lord, this is my matter. My lord, I was pleased to allow my mentioning yesterday. It is not appearing.
দেখি কেন এরকম তো হওয়ার কথা না আমার ঘরে। দেখি
কালকে মেনশন করলেন দশের টপে রাখতে বললেন গ্রুপ 3 ম্যাটার।
হ্যাঁ কি হয়েছে? লিস্টে দেবেন না কেন? ফাইল না এলেও তো আমার বলা আছে লিস্টে দিতে হবে, তলায় FNH লেখা, ফাইল নট হিয়ার। লিস্টে দিতে আপত্তি কোথায়? আমি ডিরেকশন দিয়েছি, কে লিস্টে দেয়নি কেন? হ্যাঁ বুঝতে পারছি না আমি, আমার বলুন। ফাইল আসেনি তো লিস্টে দিতে আপত্তি কোথায়? তলায় লিখে দেবেন FNH।
My lord,
That is a different issue, but
I have your lordship's leave to mention, my lord, a listed motion. My lord, prior to vacation, it was appearing. And thereafter, my lord, as per the direction, it had been mentioned that on 3/11/2024, the matter will appear. But actually, 3/11 was a Sunday. The matter should have appeared on 4th. 4th, I could not mention. And my lord, today is 5th, my lord, I
the
mentioned.
land matter,
Yes, my lord. Yes, my lord.
যেটা 3 তারিখ
It's written on 3/11.
order, is there any order that it will appear
3/11. On 3/11, it will appear. It is written there. And the last enter.
My lord, may I be permitted? My lord?
That is the thing. Mistakenly, it is printed as 3/11. It should be 4/11. Now, this matter is not appearing. Matter is
কালকে লিস্টে দিয়ে দিন।
extremely grateful. Extremely.
এটা কিসে থাকবে? It's under what heading?
Listed motion, group 1.
Land.
Land.
Motion land.
Grateful.
My lord, may I mention?
আর ওইগুলো যেন কালকে থাকে, যদি ফাইল এসে না পৌঁছয় তলায় লেখা থাকবে FNH, কিন্তু কোনো রকম যেন আমার ডিরেকশনের অন্যথা না হয়, আমার যেন শুনতে না হয় লিস্টে আসেনি। Yes.
My lord, first Shubho Vijay, my lord.
Yes.
My lord,
All of you.
I'm praying for leave, my lord. My lord, an order passed under section 10(4) of the Highways Act. Initially, an order was passed that was squashed by your lordships, being bereft of any logical conclusion as to how they have come to that finding. Now, my lord, again, the same verbatim, same type of order without any reasoning has been passed, my lord. And now the police is saying it was passed on 12th of September. My lord, mischievously, it was served on us on the 23rd of October. And now the police has come yesterday. We had prepared a writ petition and they are going to demolish it tomorrow, my lord. So, my lord, may I have my lord's leave, my lord? I will file it and serve them, my lord. Can it be listed tomorrow, my lord? Because otherwise it will not be demolished.
Obtain the number, then you mention.
So, my lord will otherwise, my lord, they will not allow us.
Obtain the number,
My lord.
you then mention at 1 o'clock, I will direct it to appear tomorrow.
I'm grateful, my lord. I shall.
Urgency pleaded. Leave is granted to obtain regular number.
I'm grateful, my lord.
On urgency pleaded, leave is granted to obtain regular number. Then you ask your junior with the number to come to me and mention at 1 o'clock. I
shall do the next. I'm grateful, my lord.
Yes,
Sir, I was praying for your lordship's leave to mention the 10F appeal that your lordship was hearing. Well, your lordship had, my lord, kept the matter on the 7th and thereafter on the 21st. My lord, 7th, unexpectedly, my lord, I am in some difficulty, professional difficulty. my lord, where I have to be, my lord, before the Honorable Supreme Court. My lord, that is why I was
Where
preparing
is
for
the other side?
Lordship, I am
Yes,
the,
well,
Lordship, I
I'm
am the
mentioning-
appellant, Your Lordship, in the other matter, so it's very difficult to oppose Your Lordship, Mr. Saha. But Your Lordship, February, Your Lordship, we have concluded our arguments. In March, they have commenced. My instruction, Your Lordship, on the last occasion, Lordship, I've observed, Mr. Shah is not available. His immediate
It will
next
appear
junior will
on-
be available.
When it will appear on 7th, ask your junior to mention that, and they should be here. Somebody should be here,
Yes,
I will
so
be
that
here.
consent can be granted,
Yes.
if they grant. And it will then have taken up again on 21st.
And
Great.
before that, if Your Lordship, because we are suffering for an order of injunction, Your Lordship.
Next.
May I permit to mention a matter, Your Lordship?
Yes,
Mention for inclusion in the daily list, Your Lordship. It's a group 1 land matter. Your Lordship, I am owner of a land. My font is belong to the.
all right, wait for 2 weeks, then you mention.
There's a problem for get in and out from my property
Why?
because my font of land is belong.
Eviction proceedings started.
No, Your Lordship, it's belong to PWD. My one of the villagers is erected and encroach some illegal construction over here.
Nothing, no urgency. Next.
My Lord, may I prefer Your Lordship's kind leave to mention a matter for inclusion. My Lord, subject matter of challenge, my Lord, is an order passed by the appellate authority under the Urban Land Ceiling Act. My Lord, what had happened, the private respondent, who is an adjoining landowner, was initially granted exemption. Thereafter, my Lord, the factory was closed.
Already mentioned after 2 weeks.
My Lord, I had mentioned, my Lord, before the vacation. My
That's right, after 2
Very
weeks.
May be permitted to mention, Your Lordship, a Group 3 matter, Your Lordship. The petitioners are contextual employees of the CPWD. They had prayed for an equal pay for equal work in accordance with the.
Wait for 2 weeks because I have to today itself, I will call the list.
There is
So let
some
me see what
urgency,
is
Your
the
Lordship, with
position,
regard-
then you, after 2 weeks, you mention. Yes,
May I have Your Lordship's kind leave to mention a matter for restoration aid? This,
Mike.
may I have Your Lordship's
Restoration.
kind restoration of a Group 3 matter, where I challenged the actions of a recovery officer but issued show cause notice. I have been called during the pujas and before the puja. It was
When
mentioned before
dismissed?
in 2023. The December 23, it was
23
mentioned before. Yes.
Application with section 5.
No, it is just the application. I'll Section 5 is also there. Your Lordship kindly include it in the list because it's the other connected matters are coming on 7th. There is a different repetition also.
That doesn't matter.
My
It's a
repetition was discussed.
restoration application.
I'm mentioning.
Application heading এ দিয়ে দিন আজকে কত তারিখ? Seventh application.
Grateful.
7th November application.
Mentioning upon notice, Your Lordship, I have handed over the notice.
Give another notice that I have fixed it on 7th.
Grateful.
7th application.
To be mentioned item number 1.
ম্যাডাম, এই যখন রোজ লিস্ট করবেন না, একদম যা মামলা ডিরেকশন যেদিন থাকবে সেই দিন আসবে। ফাইল না থাকলে আপনার কিছু করার নেই, আমাদেরও কিছু করার নেই। তলায় লিখে দেবেন FNH। এটা যেন আমার শুনতে না হয় বসেই। ঠিক আছে? থ্যাংক ইউ। এটা কি মান্থলি লিস্ট? এটা কি মান্থলি লিস্ট? হ্যাঁ। যেটা ঠিক আছে, সে আবার আসবে। কিন্তু যেখানে আমি স্পেসিফিক ডিরেকশন দেব সেটার যেন অন্যথা না হয়। কাগজ না থাকলে নেই, কিন্তু মামলা লিস্টে থাকবে। সেটা তখন ভাববো কাগজ নেই কি করা যাবে। Yes, to be mentioned. Why?
It is for correction. Lossy in the first page, paragraph 5, lossy third line. Encroach on the piece of petitioner let.
One second. third.
First page, fifth paragraph, third line, Lordship. Encroach,
Petitioner complained of an alleged unauthorized construction and encroachment on the piece of
piece of
petitioner.
petitioner land. It is a
PWD
government.
land.
Yes.
It should be PWD land.
Yes.
Asho.
Another thing, Lordship, page 2, paragraph 4. Lordship, fourth line, last report from the respondent 8 and 9 instead of 8.
Report from respondent number?
It was typed on 9.
Huh.
9 is the private respondent. Report from the respondent 8. 8 is the BLO.
লিখো। কি বুঝতে পারলাম? কার আপনার? আচ্ছা, তো আর ওই পিএস এর কি হলো? আচ্ছা, যাই হোক, আপনি ডিকটেশন নেবেন, এই তো? ও, উনিও নেবেন? সেটা কি একই দিন ডিকটেশন দুজনে নেবেন না আলাদা আলাদা? আচ্ছা, যা পারেন করুন, আমার কাজটা হলেই হলো। যা পারেন করুন, এত কথা বলে আমার লাভ নেই। যা পারেন করুন। নয়তো আপনি ওই আমারও তো মেশিন আছে ওখানে, আমি যখন কোর্টে থাকবো গিয়ে করে নিতে পারেন। ভুল হলে গেল। নিন। Today, the writ petition appears under the heading to be mentioned at the instance of the petitioner to correct an apparent typographical mistake on the face of the order dated October 7, 2024. Full stop. In the fifth paragraph of the first page, in the fifth paragraph of the first page of the order, it should be read as unauthorized construction and encroachment on the piece of PWD land instead of petitioner's land. Paragraph. In the penultimate paragraph at page 2 of the order, in place of respondent number 9, the report shall be of respondent number 8. The inspection report shall be of respondent number 8. Paragraph. Instead of respondent number 9. Paragraph. The above corrections be incorporated and read into the order dated October 7, 2024. Full stop. Paragraph. The rest of the order remains unaltered and without any modification. Thank you. Now you follow the instruction from the list.
Item number 2.
কেন 2 কেন হবে?
মানে item number 2.
Monthly list? সেটা রাখবেন, অফকোর্স। আপনি ওই জন্য তো বললাম আমি যে আপনি ইনস্ট্রাকশন ফলো করুন এবার।
Item number 2, I prefer not today, my lord.
নেক্সট আপনি ডাকুন, ওটা লিস্ট ফলো করুন। Read the instructions in the list.
My lord, I prefer not today, only.
ডাকুন না।
Monthly list, item number 220.
এই এটা একটু কারবার বাবা, একটু জল দিয়ে দাও তো। কত মোশন? একদম ডাকুন না, আগে ডাকুন, দেখি কেউ আসে কিনা। প্রথম দিন কিছু উল্টো পাল্টা করে লাভ নেই, কাল থেকে উড়িয়ে দেবো, আজকে কিছু করবো না। হ্যাঁ, ইয়েস, ডাকুন দিদি। Passed over for the day.
221.
Well, I am for the respondent provident fund authorities.
Passed over.
222.
Well, I am for the respondent provident fund.
Passed over.
23.
Passed over. Passed over. Oh, you are for the petitioner, 224. Yes, what's the matter about? Take the microphone. Keep it first. Let me know. না ফেরত দিয়ে দিন, কারণ আজকে আদার সাইড নেই তো।
But the point is very short. The petitioner before your lordship has seen in Bata shoe store. In the Bata shoes,
Growing old.
does
Take
it
the
look
microphone.
so? Does it look so? At least your lordship.
Yes.
Lordship, the thing is in the Bata shoe shops. Bata has got two establishments. One is factory at Batanagar, where the manufacturing process, or throughout India, other places the manufacturing process are there, and the other place is where the Bata shoes are being sold. Sold. The Bata shop and all these things. In Bata shop, there are two categories of employees. One is our own employees, who are
Your own mean Bata companies.
Bata company's own employee. Another, when
Contractual.
prior to that, now it is being contractual, team lease and all these things have come. That is in 2008. Prior to that, the system was whenever there is any rush in the market or any festive seasons were there in our old days, we have seen, in our child days, we have seen, many people are there in the shop who doesn't wear the Bata logo and all these things. They called by company at that relevant point of time, material point of time, as temporary hands. For the spike in the business, they used to be taken. Bata shop manager used to take his
It's the shop manager's discretion.
Discretion he used to take, but the payment was made by the Bata company. It is not the pocket of the
showroom or something.
Yes. Now, the petitioner before your lordship is a Bata shoe shop. Bata company is there. Bata shoe. The respondent number 3 was engaged as a temporary employee in Bata shoe stores. And when there was no requirement, he was taken. When there was not requirement, his engagement was
Now,
not
since
there.
the payment has been made from the company, he is claiming a right from company.
Now, when there is a disengagement, this is a normal process. When there is a disengagement,
বাবা একটু এটা একটু কমিয়ে দাও না বাবা কারবার এই কোথায় গেল একটু পাখাটা কমিয়ে দিন তো ইয়েস
when there is a disengagement, Lordship, so far as industrial jurisprudence is concerned, it is called retrenchment
retrenchment
under section 200. Retrenchment, the very first word of retrenchment is separation by the employer. Any sort of termination. It takes into account everything, every sort of separation. So far as Bengal is concerned, there is an amendment. Refusal of employment has also been taken as separation of employment.
refusal
Yes, refusal. Because sometimes I do not give the termination letter. I tell him not to come from tomorrow. So this is a refusal. So under section 2 capital A, because Industrial Disputes Act is a collective dispute where majority of the workmen or union is the party. But after the amendment of section 2 capital A, an introduction has been made. Individual person bereft of the cause being espoused by the majority of the workmen or union, he can raise the dispute. That is in respect of severance of employer-employee relationship, not otherwise. Only in respect of severance of employer-employee relationship. So far as Bengal is concerned, under section 2 capital A, an introduction and incorporation has been made, refusal of employment also. So that way it is there. We are no way concerned with that. Now, when his service, the respondent number, private respondent service has been disengaged, he raised an industrial dispute. So far as industrial dispute matters are concerned, it is not like civil court. I can go straightway and file it. First, I have to raise my dispute with the Labor Commissioner's
Labor
office. Section 12. If there is a settlement, is all right. Under section 12(3). If it is not, under section 12(4), a failure report goes.
আচ্ছা এক মিনিট দিদি ওই 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 দেখো ওই যে কালকে বেয়ার একটা ছবি দিয়ে গেছে দেখি
May I hand up my book?
no
One
no
book?
no no wait. And today in fact other side is not there
Yes, yes.
first day না না যেটা দিয়ে গেছে বললেন এটাই দিয়ে গেছে না এটা না আপনি একটা বললেন না কি ছবি দিয়েছে এই যে একসঙ্গে এটাই দিয়েছে আর ওইগুলো দিয়ে গেছে ঠিক আছে মিস্টার দে first assist the court is there any compendium of bare acts while I'll be dealing with group 3
Yes,
like
there is
like 12 bare act 14 bare act on
there is a compendium of bare act published by P.L. Mallik. All bare acts are there, industrial laws, 2 volumes.
all bare acts
All bare acts under Industrial Disputes Act.
give me I will take the photograph and I will
This is a bare act of Industrial Dispute Act. That is industrial.
that is there I want a compendium so that at least like that 18 20 25 bare acts are there
All. I will send it. No issue.
so you give it today during the lunch the book just give me the book my officer will take the photograph I will send it to the library to bring a fresh copy
Idea যে total compendium আছে industrial laws. P.L. Mallik.
thank you এটা রেখে দিন দিদি yes so that I can keep one
At least.
ready reference yes
But
then
there,
whatever you will produce all of you I will take assistance always That
but
is
so far
always.
as industrial laws or industrial jurisprudence are concerned, there are rules, governing rules.
yes and central rules state
and
rules
state rules.
that is not possible to keep here that you will have to provide whenever
Certainly, we
which
will.
will want. That's right that is always there
That's
but the bare acts I must keep one
Certainly.
yes
Now,
next
so far as section 12(4) is concerned, in a colloquial language, we say as a failure report. Once it goes to the government, it is the government who takes the decision under section 12(5) of the Industrial Disputes Act, and matter is referred by framing issues to the adjudicatory authority that are also created under Industrial Disputes Act, section 7(a) and (b), Industrial Tribunal and Labor Courts. Thereafter, these are normal thing. Thereafter,
No, but which one shall go before the labor court and which one shall go before the industrial tribunal?
now the thing is, that's why I'm coming. It is the normal procedure. Earlier it was there. Thereafter, there is an amendment by West Bengal government, section 10(1)(b), capital B, where an individual has first given the right after 60 days. I raise a dispute with the Labor Commissioner's office, the conciliation officer, or the Assistant Labor Commissioner, whoever is there, being conciliation officer. Within 60 days, if no dispute is settled.
So if conciliation succeeds, matter ends there.
Yes.
If the conciliation fails, then again further traveling.
Yes, the further travel, then that has been diluted after introduction of section 10(1)(b) by the state government. Industrial laws by the state government. By that process, 60 days, if it is not settled, under the rules, the conciliation officer will issue a certificate on receiving an application from the concerned employee. On that basis, he will go to the labor court, because correspondingly there was an introduction of a gazette notification by determining the labor courts giving jurisdiction. There are 2 labor courts in Calcutta giving jurisdiction for the districts to take over the dispute. This way it goes to the labor court. Now thereafter, in 2010 possibly, there is a further amendment by the central government. Section 2 capital A, just now I have said, individual dispute. Section the central government again amended section 2 capital A by incorporating section 2A(2) and 2A(3), where I am required to raise dispute with the labor department, and after 45 days, I am not required to take any certificate. Straightway, I will go to the tribunal. Straightway, according to the jurisdiction determined by the state government. But the limitation for the first time in industrial disputes jurisprudence, there was no concept of limitation. But for the first time, section 2A(3) has been incorporated by introducing 3 years limitation. Suppose my service has been terminated in 2015. I cannot avail the benefit of section 2A(2). I make clear to you, Lordship, because 3 years limitation. But so far as Bengal is concerned, an employee has got 3 opportunities, 3 avenues. First, he can go to the go for a reference. Second, 10(1)(b)(d). If my limitation comes into play, I will not get the benefit of section 2A(2), that 45 days. So this is the Bengal. Now we are not coming within the second 2 aspects, that 60 days and 45 days. This relates to the direct reference. Under section 12(5), government has referred the matter to the tribunal, second industrial tribunal, with a direction framing the issues. And so far as industrial jurisprudence is concerned, laws are very clear, and Supreme Court, Honorable Supreme Court has categorically said the tribunal cannot travel beyond the reference. Cannot travel.
Cannot.
If he goes anything deep into the matter, that will be bad. Because application of mind,
it's the first principles of law which is applicable for arbitration also. Common arbitration proceeding. That the arbitral tribunal cannot travel beyond the scope of reference.
Absolutely.
That if the reference is defined, the tribunal has to move within the four corners of that reference.
Certainly.
Right.
And in Bengal, in Industrial Disputes Act, there is a, in Bengal amendment, there is a provision for framing additional issues.
Yes,
Unless
possible,
it is not there,
possible.
if the party goes for additional additional issues, then it can is different.
The party will have to apply before the government again.
No, to the to the adjudicated authority.
That you have missed this issue, please incorporate it.
Absolutely. Suppose, Your Honor, Your Lordship kindly consider, Mr. XYZ termination has been referred. The stand of the government, the stand of the company is, Mr. X was not a workman.
So it doesn't come within the meaning of the
Industrial
Act.
Disputes. Yes.
Act.
Under section 2S.
2A.
So when it is there in the written statement, I will take the point he is not a workman. These are his.
So that has to be the first preliminary issue.
Yes. Then
the principle akin to order 14.
Yes, absolutely. And secondly, there are two types of separation. So far as industrial jurisprudence is concerned, one is retrenchment. Another is the definition of retrenchment. Your Lordship will find the first para, last line. Other than the punishment, imposition of punishment, as Your Lordship knows, in government service, Your Lordship has seen that I cannot terminate a person with the allegation without giving him an opportunity of hearing. That means charge sheet, reply to charge sheet, domestic inquiry, then inquiry report. If
again another, if it goes against the delinquent, another opportunity of her being heard.
Yes, that is second show cause notice, if there is any provision. Otherwise, the punishment will be imposed. This is the disciplinary proceedings. Your Lordship will not find in industrial jurisprudence regarding these disciplinary proceedings are being codified. This is a thing which has been taken from the service jurisprudence. And the Honorable Supreme Court, starting from 1963, and thereafter introduction of section 11A, Firestone's case, this process has been accepted by the Honorable
Crystallized.
Yes.
Crystallized.
And
Law
till
is
it-
crystallized.
Yes, and till today, it will be there. Suppose I terminate a person with allegation, then these processes are to be followed. And before the tribunal, I have to take a point that validity of domestic inquiry is to be heard first. This point, this Your Lordship will not find in any codified law. These are all judgments law.
Presidential law.
Absolutely. And Your Lordship will also find that the proposition of service jurisprudence are also applicable in industrial jurisprudence. Now, if we come to the facts of this case, this person in the written statement has said, I worked continuously for 240 days. Now, why 240 days has come?
Why 240 days is auspicious?
Yes, why? Because of the fact, under section 25F, an employer used to pay him retrenchment compensation. Section 200 is a retrenchment.
Yes.
And when I go, I should be paid retrenchment compensation.
It's akin to subsistence allowance. Akin to.
No, this is retrenchment compensation is my statutory right.
Right.
This is not subsistence allowance. Subsistence allowance concept, so far as Bengal jurisprudence is concerned, under section 15(2)(b. During the pendency of the proceedings, I will get it.
Yes. But retrenchment compensation?
Retrenchment means there is a severance. When disciplinary proceedings
No, but ultimately, if it is held, retrenchment was bad.
Yes.
It might be held.
Yes.
Retrenchment was bad.
Yes.
Which means induction of that employee again
Yes.
in employment.
Yes.
Then
reinstatement with back wages concept.
back wages. Then retrenchment compensation will arise.
No. Now, retrenchment compensation will not arise. Then, when my retrenchment compensation has not been paid, then prima facie, it is bad in law. So, I will be inducted then I will be inducted with reinstatement with back wages.
That's a different issue because as if there was no retrenchment at all.
Absolutely.
The continuity of employment.
Absolutely. But by the passage of law, by the passage of time, this concept of giving back wages has undergone a sea change. It is either earlier up to 1980 or first half of 1990, it was there that when termination is bad, back wages is an automatic thing.
Acha.
Now it has gone down. It has, the concept has been diluted. Certain other criteria Supreme Court has been pleased to induct when it can be not paid, full or partial, or when instead of giving back wages, compensation can be awarded. Because as your lordship knows, industrial jurisprudence has traveled the entire time period with the change of society.
That's right. Yes.
Because
and it's always a beneficial legislation.
Absolutely. Beneficial legislation. Now, concept is all, now it is, to be very candid with your lordship, don't take me amiss. So far as industrial law is concerned,
Ignore. Yes.
It is not meant for the employer, not meant for the employee, it is made for the society, the Supreme Court has said in the Jaiveer Singh's case. So beneficial piece of legislation doesn't mean that the employer will suffer in such an extent that induction of that person will
cause a tremendous and irreparable prejudice for the employer.
That is the thing.
So of course, that has to be.
Yes.
Has to be.
So it is to be viewed in this way. Now, so far as this case is concerned, lordship, termination.
And these type of level legislations, industrial legislations, which are beneficial by nature, these are always a balanced legislation.
Absolutely.
It's always a balanced legislation.
Absolutely. Now, lordship, so far as this thing is concerned, factually, what your lordship has at the very initial stage your lordship has opened your lordship mind that contractual employees. After 2008, management took a policy, that documents were also there, and everybody knew, the temporary hand knew that Bata company has stopped taking temporary hands. It is manpower are being supplied by team lease, pan-India basis. Now, he raised the dispute, and in the written statement he said...
No, first tell me, what was his nature of appointment?
Temporary hand. Absolutely.
So, before the contractual concept came, he was appointed.
He was there. We are not denying. Temporary hand, pay sheet, all are admitted. What I am submitting before your lordship, all are admitted.
Now, what he is claiming now?
Now, he has said, 240 days I worked.
Correct.
Now, why 240 days is auspicious? Retrenchment compensation, section 25 says, continuous employment. And continuous employment has been defined as under section 25B of the ID Act, which speaks about 240 days working. So a person who works for 240 days, he has the right to get retrenchment compensation. Now, in industrial jurisprudence, 240 days working assertion is not enough. He has to prove 240 days working. I will show in this case 3 pages why it is perverse, why the award is perverse. He, in his written statement, has said 240 days I have worked continuously. In cross-examination, he has said I cannot produce any document to show I have worked 240 days. And I have, in the written statement, I have not said that I worked for 240 days, not in the entire tenure. It has to be shown in the 12 calendar months. So 1 year he has to show prior to retrenchment.
Out of 365.
Out of 365. These are the admitted facts. The learned tribunal has said, and the law laid down by the Honorable Supreme Court is, 240 days working, the burden is on him to show, at least with something, that 240 days he worked.
So with some unimpeachable evidence.
Absolutely.
Unimpeachably, he has to show continuous 240 days without any interruption.
Then burden will be shifted to the management.
Management.
That,
To show that he is wrong.
yes. Now, admittedly, written statement, he has said, I worked for 240 days. In the evidence, he has said, I worked for 240 days. In cross-examination, he could not prove. When we raised this point during the time of argument, tribunal has come to the conclusion that burden is always on the company because of the fact he never said that I work for 240 days. Totally being oblivious of the fact, in the pleading it is there, in the evidence it is there. And to be very, other positive thing, to be very candid before your lordship, the petitioner before your lordship is in a very perplexed situation. Because in a temporary hand, in a case of this nature, in case raised by the, in case of a dispute, the learned tribunal, at the very initial stage, in respect of other case, granted back, did not grant him reinstatement with back wages, only granted 50,000 compensation, rupees as compensation.
Retrenchment compensation.
Not compensation. Retrenchment compensation is a statutory one. Compensation is a discretionary one.
Okay.
Now, compensation 50,000. The workman challenged the matter before this honorable court. Honorable Justice Tandon, as his lordship then was taking up this jurisprudence, Group 3 matters, his lordship was kind enough to uphold the award and only just increase the compensation from 50,000 to 75,000. He went to the division bench. The honorable division bench has confirmed in respect of Bata, temporary hand, same nature. 75,000 confirmed. So far as other cases pending before the first industrial tribunal, this was before the learned second industrial tribunal. In the first industrial tribunal, the similar case, temporary hand, everything, the learned tribunal awarded an amount of rupees 1 lakh. We said that yes, 75,000 it is there. If your lordship, if your honor kindly increase, we don't have any thing to say. It was paid 1 lakh. 4 persons were there, 4 lakhs.
No, but now this gentleman
has reached the age of 65 years. He has been ordered to be reinstated with back wages from 2008. And when we have submitted 1 lakh rupees as a compensation, the learned tribunal or the honorable court 75,000 has paid. 1 lakh has been given as a cost on us.
Achha, now you tell me.
And so far as
this gentleman, so far the claim of this gentleman is concerned, the moment he was granted with employment with back wages, which means the authority held his retrenchment was bad.
Yes.
Retrenchment
Yes,
was
yes,
bad.
yes.
What was the reason for holding retrenchment was bad?
Because 25F has not been complied with.
What is that?
That retrenchment compensation, 240 days continuous service.
Oh.
The basic genesis is 240 days.
Authority proceeded that yes, there was a 240 days continuous service. Therefore,
the retrenchment is bad, and the management has said that team lease has been inducted. There is no system of severance of system.
That is a different thing.
No. He has come. He has come. The perversity I am showing before your lordship, the learned judge has said, since I have seen continuously in Bata shop that other employees are working who are not the company of Bata. So the stand of the company that they have stopped the engagement of temporary hand, this is wrong. This is the finding of the tribunal. Not within the framework of the
Proceeding.
Yes,
Personal knowledge.
absolutely, the perverse. Absolutely, I am challenging this thing on perversity. And the law of the land, the Honorable Supreme Court has said 240 days, the burden is on the workman.
No, that's all right.
So this is the point of law. If it is goes, now Lordship,
Just clear my mind on one
kindly,
issue.
kindly, Lordship.
So let's hypothetically take a case. A clean slate of 240 days walking.
Yes.
No doubt. What a tight case. Then retrenchment permitted.
Yes. 240 days. No, 240 days working and retrenchment are different things. 240 days working grants a right to the employee to get retrenchment compensation.
Receive retrenchment compensation.
Absolutely.
Now, when the authority is holding retrenchment is bad, employ him with all back wages as if there was no interregnum, no entrenchment. What was the ground for that?
240 days. He has worked continuously for 240 days.
So I'm asking you the same question.
So that's why he.
So let's take a situation. Don't forget it about this fact. Hypothetically, take a situation when there is unimpeachably 240 days walking. No doubt about it. Employer also admits. Then can an employer proceed for retrenchment?
Yes.
He can.
Yes.
So when the authority has held retrenchment is bad, then how it's concerned with 240 days? 240 days may be concerned whether retrenchment compensation is payable or not. But retrenchment is bad. To come to a finding that retrenchment is a bad, what are the necessary
Now, so far as
ingredients?
retrenchment is concerned, under Rule 77, there are procedure which has to be which has to be followed.
That's
That is
right.
last come, first go. I can whimsically, I
No,
cannot.
That is possible. There are procedural infirmities.
Yes, that's the ground for.
So here the authority tribunal has held that there are procedural infirmities.
No.
Then what is the ground?
240 days, he worked continuously, and the burden is on the employer.
Sir, Mr. Dey, perhaps I am not clear to you. He has worked for 240 days. Let's admit, for argument's sake. Even don't take this case.
I see.
Don't take this case.
Okay.
Hypothetically, a workman worked for 240 days, which means if retrenchment happens, he will be entitled to receive retrenchment compensation. So 240 days is important to decide retrenchment compensation, whether payable or not. That has got nothing to do to declare a retrenchment bad or good.
That has.
If there is a procedural infirmity, procedure let down, in violation of those procedures, retrenchment took place. Of course, retrenchment is bad. Of course, retrenchment is bad. But to come to a finding for that reason, retrenchment is bad, there is no requirement of a finding whether he has worked 240 days or not. Concept will be, that's why I'm asking you, twofold. If the retrenchment is bad for procedural infirmity, and if he has worked 240 days continuously, then he will get the retrenchment compensation and he will get an award as if there was no retrenchment. So, employment with all back wages plus compensation.
Not compensation.
No compensation. Right. So, when one has to come to a finding that retrenchment is bad, he has to come to a finding with the help of finding that procedural infirmity is there.
That is the only thing.
That's right.
That's the only thing.
Now, let's say procedural infirmity is not there. Retrenchment is good otherwise in law. Then the question will come whether 240 days continuous working is there to allow him to get retrenchment compensation.
Procedural irregularities were not there.
Right.
then
Retrenchment is bad.
retrenchment is bad.
Bad.
Then 240 days, whether I have paid him or not, that
It
is
does not
immaterial.
matter.
That is immaterial.
Immaterial. But if the procedural infirmity is there, retrenchment is, is not there.
Not there.
Retrenchment is good.
Good.
Maintainable in law. Then question of 240 days will come to assess whether he will be entitled to retrenchment compensation.
Absolutely.
Right?
Absolutely. Because justification of retrenchment will be there.
That's right.
Justification of retrenchment.
That's
With
right.
that the tribunal has got right, because that issue will be framed in that way.
Yes.
Justification.
Now those will be examined in the light of the facts and documents.
Absolutely.
That is a different issue.
Absolutely.
That is a different issue.
Absolutely. Now,
all right. But today,
no,
nobody is there.
this
And
is the sum-
I took the opportunity to get acquainted with the procedures and the law. Thank you for that. I took that opportunity. And he was seriously backbited by somebody else with the side comments. He has flown. He has flown away.
And Mr. Pal is also, he has handed over the baton to Mr. Pal, I think.
Oh, is it?
Yes. He's a very soft way.
Yes.
His biting is more dangerous than
Mischievous.
Mr. Majumdar.
Don't say dangerous, say mischievous. All right. Acha, so first thing is, the
Have
gentleman has to be here. I
Other
mean,
side-
he has to be represented.
Absolutely.
Whatever.
I have given notice, and affidavit of service is present, is there also.
Ashun.
My
Thank
point
you.
is very simple.
I took this opportunity. Ashun.
This height of embarrassment, nothing.
Why?
And why? Because Your Lordship, you have seen, Your Lordship, Mr. Pal is there. So I know what will be my fate outside the court.
Mr. Ranjoy De, you give your name, sir. Being ably assisted by Mr.
Adityajit A. Bose.
এসব বললে বাবা বুঝবো না গোটা গোটা করে বলো লিখে দাও
আচ্ছা
What's your name, full name?
Adityajit A.
Adityajit. Then Adityajit Bose. That is advocate appearing for the petitioner has submitted on facts. Just to give a brief outline of his argument in the matter. Paragraph. None appears for the respondents. Paragraph. Considering the nature of the proceeding, the respondents, specifically the employee concerned, must be granted another opportunity to be represented and to place his submissions. Accordingly, the writ petition shall appear under the heading motion ব্র্যাকেটে দাঁড়ান ওই লিস্টেড কোট আনকোট লিখতে হবে লেবার এন্ড ইন্ডাস্ট্রিয়াল ঠিক আছে মোশন ব্র্যাকেটে লেবার এন্ড ইন্ডাস্ট্রিয়াল on
Whatever suits you, Lord.
no you have to serve then
I have to serve the individual because I do not
that's
know
right,
with,
that's right.
again I will serve a notice, nothing else.
That's right. Give me a date. আজ তারিখ কত 5
After 15th, any day, Lordship?
19th November 19, 2024. The petitioner shall serve notice upon the respondents and file an affidavit of service when the matter shall be taken up next. Okay,
Lordship, only one thing, serve again, because I have already served.
মাথার উপর লিখে দিন affidavit of service filed today in court is taken on record.
Second one is again, nothing else.
I'm taking the affidavit of service.
I'm
Affidavit of service filed today in court is taken on record. Private, the employee has been served.
Yes.
All right. তাহলে ওই জায়গাতে একটু লিখুন তো কি লিখলেন দিদি পড়ুন না পিএস comma despite notice. Mean it.
I'm deeply aware.
Thank you so much. Next.
Item number 225.
Item 225, petitioner. I'm praying for days accommodation, Your Lordship. I have some mistake.
Huh?
I'm praying for today's accommodation, Your Lordship.
Passed over for the day. Next.
I appear for the petition.
Passed over for the day.
Yes, I am for the petitioner here.
Passed over for the day. In any event, give one more notice, sir. Give one more notice. I'm not recording any order because then it will go out. So let it remain in the list and all of you give notice.
It is applicable to me, for me also. I'll
Yes,
give it
yes, for everybody, because I cannot take up the matter because of the two things. First, respondents are not there. I don't wish to take up extra.
1 week's time will be there.
And these are, after all, a decision on the livelihood.
So 1 week's time will be there.
Yes. So it will remain in the list. Give notice.
For the petition, for the petition, 228 and 229.
Same. Passed over for the day. Give notice. Same. Yes, what's happening? Nobody will do the labor matters. চলুন next ডাকতে থাকুন
31. 33.
In this matter, I bring on behalf of the petitioner. This is relating to gratuity. The gratuity was not paid by the employer. Your Lordship. There's a employee has died. His deceased wife filed an application form.
Passed over for the day. Give one more notice.
Yes, Your Lordship. I have since served this.
I understand. Let me see. First day, after all.
Employee will never appear. There is a history.
Let us come back from the vacation mood.
No, Your Lordship. No, Your Lordship. Okay. I will serve the another one.
34.
Same.
45.
পরের দিন থেকে পিটিশনার যদি না থাকে ডিসমিসালে পাঠিয়ে দাও
36. 237.
Give notice and come back.
Affidavit of service is there.
Keep it with you. On the next day you file, give another notice and come back.
38. 39.
I am for the respondent.
Next.
241 for the petition, my lord. The petitioner has engaged and senior has decided to engage a senior with me, my lord.
Huh?
The petitioner has decided to engage a senior along with-
Decided. How does it matter? You are there.
My lord, I've been informed that he wants to appoint a senior. My lord. Kindly keeps it next week, my lord. In that case, my lord.
Passed over for the day, sir. But why don't you do?
My lord,
Why don't you do?
but I am ready, but
You're ready?
this petition.
Come ready on the next day. Get more ready.
41. 42.
About the petitioner, Lordship.
43.
Just give one more notice, Mr. Pal. I'm not mentioning because if I pass an order, the
First
matter
time, this is
will
the
go.
first time appearing, Lordship. I have served to the Union Office, Lordship. So I have to give you another notice to the Union Office, Lord.
I do not know, sir. Whoever give notice.
43, I am for the petition.
43? Yes,
43.
yes.
Well,
No, but other side is not there. First day, I'm calling the labor matters.
It will retain its position, madam.
It will remain passed over for the day. But give one more notice, Mr. Sarkar, so that I'm not mentioning anything in order. Give one more notice.
44.
Same.
Or my lord, one line direction, the petitioner may serve.
Then again, the matter will go out from the list. If I pass an order, then
45.
45.
Your Lordship, I am for the petitioner, Your Lordship. The service has not been yet completed. Your
very
Lordship, I am
well,
praying for
passed
1
over
week's
for the
time.
day.
Your Lordship, this matter will be taken up after 1 week, Your Lordship. The state has to
No,
be
then,
served.
then monthly list of
Your Lordship, then
January.
passed over for the day.
Passed.
Obliged.
Obliged.
Your Lordship, in this matter also service has not
I am
been
appearing
completed.
for one of the private respondents in this matter.
No, she confesses that service is not complete.
The state has to.
Let her
No, we
complete.
have also not been served with a copy of writ petition.
Give her
Your
here
Lordship,
and
I'll
now.
supply by today.
Give her here and now.
Your Lordship,
All
I'll
right.
supply.
Grateful, Lordship.
48.
I am for the petition. I shall serve notice.
What's happening? Nobody is interested to the labor matters.
So, Lordship, I don't think so, Lordship. They are interested, Lordship. Next day, I think, next day they will be.
That's why I don't disturb the list today. Next day onwards, if the petitioners are not there, it will be placed for dismissal.
If no accommodation is paid for.
Eh?
If no accommodation is
Of
paid
course. I don't
I
do
know,
that.
I know.
I don't do that.
48.
48.
49.
And I always expect the juniors must grow up. The juniors must come. Let them start. Then the seniors must come. The busy seniors must come. Let them start first. Yes. 250, you are there.
I was in 249.
Give one more notice. Mr. Pal, Mr. Mojumdar, all of you, learned members of the bar, please give one more notice.
Difficult, I tell you, Lordship, but this is really in these labor matters that contesting respondent would be the private one.
Absolutely, the employee or the employer.
Giving one notice, will be getting the matter urgent for another 7 days or 10 days at least. Because we have to wait the outcome of the service.
No, if you give notice, and even if, let's say, it is called on tomorrow, if the service is not complete, ask your junior to come and say service is not come. I will just keep it passed over.
First time, these are being called for the first time, so we don't know who are the learned advocates representing the respondents. That's probably.
No, but you have to serve in person.
That's it. So it will take 7 to 10 days time.
But if I pass an order, the matter will go. That's the difference.
Wait for the inertia of rest to be over.
That's right. If I pass an order, then again the file will have to go, matter will have to.
Probably not this first week is to the inertia of rest.
That's. চলো next দাঁড়ান এবার now follow the list কি আছে কি বলা আছে আজকের লিস্টে then motion land আজকের লিস্ট থেকে ডাকো
Item number 2.
today's list Bojo Karwa Passed over for the day.
Your Lordship, I'm representing the petitioners. The service could not be completed due
All
to
right.
the commencement of the puja vacations.
On the prayer of Mr.
Achishman Chakraborty.
Full name,
Achishman Chakraborty.
Achishman. তো সুন্দর নাম এত কায়দা করে বলে না, বুঝতেই পারে। Achishman Chakraborty. Learned counsel appearing for the petitioner, comma. Since service has not yet been complete, comma. The writ petition shall appear under the heading motion within bracket land in the monthly list of January 2024, paragraph 2025. খবরদার ভুল করবেন না, প্রথম এরকম হবে। 2025, paragraph. The petitioner shall serve notice and file affidavit of service when the matter shall be taken up next.
I am for the petition paying for not today. Today I serve the copy GP office.
Passed over for the day.
Number 5.
Passed over for the day. দেখুন মোশন, হ্যাঁ দেখুন মোশন ল্যান্ড মান্থলি লিস্ট, সিরিয়াল নম্বর কত দেখুন। এই 14 থেকে সব স্পেশালি অ্যাসাইন। ও না 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 না, ওটা অন্য জজ স্যার, আমি ভুল দেখেছি। চলুন চলুন।
Monthly list item number 4.
Yes.
Appearing in your petition, my lord.
But I am for the respondent
Matter.
I am for the
And
private
he is
respondent
engaged,
number
my lord,
6, your
in
lordship.
court number 18.
Who?
Mr. Somen Dotto, my lord. So, my lord, matter can be passed over for a while.
Passed over for the day.
For the day.
He specifically undertook to the court that no adjournment will be prayed for.
No, no, I am praying for Passover only. Today we are ready, my lord, to do this
All right.
matter, my lord.
Remind me on tomorrow if adjournment is sought for or Passover is sought for. Tomorrow I will not grant Passover. Next.
Item number 9.
9. এটা কত লাগে 9 তো losses this map relates to West Bengal Public Land and Unauthorized and Occupation Act, but this court has no
Determination, residuary.
No, code number 17 specifically mentioned. My lord, honorable justice Joyson.
Mr.
Taposh
Kumar Majumdar, learned advocate appearing for the petitioner fairly submit in his usual fairness submits that this writ petition does not pertain to the determination classified under the heading quote unquote land. Postum. Paragraph. None appears for the respondents. Paragraph. Accordingly, this writ petition is directed to go out of the list of this court and to appear before the appropriate bench. Full stop. The records are directed to be sent before the appropriate bench forthwith.
I'm grateful.
Thank you.
Lord, I beg to appear on behalf of DFCCIL, that is respondent number 5.
Ma'am, for the petitioner, my lord. In fact, my lord,
Who is the actual respondent?
my lord,
Oh,
we
state?
no.
State.
No, no.
Where is state?
11,072.
Last occasion, my lord, somebody appeared for the state. When it was, my lord, my lord,
এটা কত রাখলেন? 12 তো for orders. নাকি? 12 of?
Your Lordship was pleased to fix this matter today. Directed the matter.
Monthly list.
Yes.
Monthly list 12 তো for orders. হ্যাঁ? ঠিক আছে। আচ্ছা। Where are the other respondents?
my lord, state respondent, my lord, somebody appeared, my lord, it is appearing in the record, it's order itself, my lord, somebody appeared.
Last occasion.
অনির্বাণ দত্ত,
My Lord, I have Anirban Dotto for
কৃষ্ণ বন্দ্যোপাধ্যায়, রিতেশ কুমার গাঙ্গুলি।
And in fact, my lord, I have challenged my lord, order of the district magistrate. My lord, state,
No, it's all right. It will appear under the heading for order on some other day.
my lord, in the supplementary list, my lord.
Let them come
Okay.
because today I will have to call the
I will sub notice, I will
land
sub
matters.
notice.
Yes.
My Lord, in the let there be an order.
Huh?
Let there be an order fixing that.
Order,
Doing that. Mr. Supriyo Chattopadhyay, learned advocate, appears for the petitioner. Paragraph. Mr. Anirban Dotto, learned advocate, appears for the respondent. Paragraph. None appears for the respondent number 1 to 4. Though on the last day, on July 31, 2024, then a junior standing counsel appeared for the state respondents. And a junior standing counsel, Mr. Shishanno Bandyopadhyay, appeared for the state respondents. In view of the above, the petitioner shall serve one more notice upon Mr. Bandyopadhyay along with a copy of today's order. Paragraph. The writ petition shall appear under the heading for orders on November 19, 2024. Paragraph. It is made clear that in the event the respondents are not represented on the next day, the matter may be proceeded in their absence. Sure. Thank you. Ashun. Next.
My lords, we appear for the NHA for respondent number 4 and 5.
Petitioner in 13, the private respondent report.
My lord, we appear for NHI, respondent number 4 and 5 in both the matters.
I am for 14, my lord.
Everybody is here.
Yes.
State.
State is not a party, my lord. The Union of India is a party, my lord, but the NHI is the answering respondent, my lord.
Yes, my lord. We are directed to file, my lord, we were directed to file 2 reports. We are filing the same. We have also served a copy of
You
the
are appearing
reports.
for?
For NHI, my lord, respondent number 4 and 5.
Have you served the copy?
Yes, my lord.
You have filed. You will file your exception.
Exception, my lord, is ready. My lord, I'll just have the copy on the, my lord, my
Exception.
exception.
So do that, and then it will appear some other day.
My lord, my lord, copy has been received on behalf of me, my law clerk, but somehow it misplaced. One copy is required to file exception.
That I do not know. That you ask him. That you request your learned friend. Ashud. What? Wait. Mr.
Dutiman Banerjee.
Dutiman Banerjee, learned advocate, appears for the petitioner. Mr.
My Lord Shayande. S.
Shayande. Shayande, learned advocate appearing for National Highway Authority of India, files reports in the form of affidavit.
Yes, my Lord.
Two
reports in two matters, 13 and 14.
13-14 একসঙ্গে order করুন. Two reports in both the writ petitions in the form of affidavits, comma, the same are taken on record. Full stop. Copies have already been served. He appears for?
My Lord, same.
Acha.
Well, so
Mr.
14, Yudhishthir Maiti.
Yudhishthir Maiti.
Yes, my lord.
Learned advocate appears for?
14, item number 14, Srikanta Ghosh.
Petitioner in 14.
Is the petitioner appears for the petitioner in the in WPA 20738 of 2024. WPA 20738 of 2024 paragraph. Learned counsel for the petitioner files two exceptions.
One. My Lord, I'm using an exception, my Lord, in my matter.
Files exception in the form of affidavit to the report submitted by the NHAI in WPA 13064 of 2024, comma, the same is taken on record. What about you?
My
You
lord,
will not
next,
file any exception?
my lord, not yet.
Will you file or not?
I will file, but not yet filed this way.
Paragraph on the prayer of Mr. Yudhishthir Maiti.
Yes, my lord.
Learned advocate appearing for the petitioner in WPA 20738 of 2024. Time to file exception in the form of affidavit by his client stands extended till, give me a date.
In the month of December.
December 3, 2024. Poster. The writ petition shall appear under the heading for orders on December 10, 2024.
My lord.
Obliged, my Lord.
My lord.
Sure. Next.
Madam, Mr. Devajiti Basu is appearing for the petitioner and he is suffering from viral fever, my lord.
Passed over for the day.
Yellow qualification.
My lord, on behalf of response number, on behalf of Mr. Sama Prasad Purkait, my lord, who will appear on behalf of the response number 8, my lord, he is unable. I pray for not today and not tomorrow.
Then
Mr. Ashun. Mr.
Devajiti Basu.
Devot, your name.
SM Hassan.
SM Hassan.
S.M. Hassan, learned advocate, appears for the petitioner. Mr. Probal Mukherjee, learned senior counsel, appears for
Respondent number 7.
private.
Port Trust. No, Port Trust.
Respondent number 7. Mr. Your name.
Prakash Chandra Mondal, on behalf
Prakash
of response number 8.
Learned advocate appears for respondent numbers
8.
8.
Respondent number 6, Rejaul
Name.
Alam. Rejaul Alam.
Mr. Rejaul Alam, learned advocate, appears for respondent number 6. Paragraph, Mr. Soumitra Bandyopadhyay, learned state counsel, appears for respondent numbers 1, 2, 3, and 5. On the joint prayer of the parties, the writ petition shall appear under the heading for orders on December 17, 2024.
Lord. December.
Grateful.
Thank you.
We are for the petition.
Yes,
My lord, I am for the petition.
unauthorized construction.
No, no, no. Well, compensation notice in the highway, notice was
Where
given.
is the other side?
No, last day, Mr.
Dekhi,
Mukherjee
kagaz
was
dekhi.
there. Evidence service. Evidence service.
দেখি দিন
কার? সেটা তো দুটো। পরের দুটো।
সৌমিত্র বন্দ্যোপাধ্যায়, প্রিয়ব্রত বটদ্দাল। Yes. Where is your affidavit of service?
This is already filed. Right?
On the last day, 18 July 2024, there was a direction to serve upon the non-appearing respondents
Yes,
and
yes,
file
yes,
affidavit of
I have
service.
been told that it already appeared and then it was filed. দেখি রেকর্ডটা
Mr. Counsel, after 18th July 2024, today it is appearing. How could you file? Show me.
Oh, no, 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 no. I am on instruction. I was not there.
ছিল না অন্য একটা ম্যাটার এর সঙ্গে হিয়ারিং হবে
কোনটা?
এইটা
তো তুমি ছিল এতে?
না আমি তো দেখছি যে আমার ইয়ে আছে এন্ডোর্স
ওটা কত বলো?
4312
4312.
দেখান দেখান।
Well, there is a direction passed by my Lord Justice Subhra Ghosh. The another matter 4312 of 2021 be tagged with the instant case.
Yes, and that has been dismissed by your lords. The tagging.
দুটোতে একসঙ্গে হওয়ার কথা।
তোর বাবা এটা appear করেছিল. We do not know. We are not there.
What has been dismissed is dismissed.
Yes, yes. Let it be recorded, madam. Because
Why should not? Why should I?
no, this has been one.
Order is there of dismissal. Why should I again
Oh,
record
it
it?
has not been. তোমার আছে কিন্তু এখানে কোনো ইয়ে নেই।
Forget it. What about this matter? ওনাকে কাগজটা দিন 18 জুলাই এর অর্ডারটা দেখুন উনি।
Yes, yes, madam, I understand.
You have not filed affidavit. In filed নিন।
Then he has no knowledge. I'm sorry, my lord.
The last order dated July 18, 2024 speaks for itself. Full stop. Since the service of notice has not been completed and the affidavit of service has not been ready as submitted on behalf of the petitioner, comma, the writ petition shall appear under the heading motion land in the monthly list of January 2025. Next.
Yes.
Petitioner shall serve notice upon the non-appearing respondents and shall file affidavit of service when the matter shall be taken up next. Next. পরেরটা রাখুন।
প্রসন্ন। Yes.
Yes. দিন।
This is my lord acquisition by or.
Take the microphone, sir.
Yes. It is my lord acquisition of the road for the national highway. This my lord.
Your land has been acquired.
My land has been acquired. My lord, if you drop
Acquired.
Yes, acquired.
Then
Yes, sir, has
compensation.
been there. That is for that we have. My lord, if your lordship turn to page 23.
Compensation paid or not?
No, that is why we have come.
No compensation paid.
No.
Compensation crystallized, ascertained,
My lord,
determined.
in this writ petition, my lord, my learned friend admitted lordship, they have already participated in the hearing, they submitted the documents. Now, lordship, his only grievance, lordship, the amount has not been disbursed among the lordship. The
Yes,
disbursing part, lordship, the disbursing authority, lordship, the state, lordship, the competent authority.
You have deposited the amount.
Yes, my lord.
It's lying with the special land acquisition
My
officer.
lord, because lordship, they have been.
This will be direct.
For state.
On the last occasion, তুমি তো ছিলে তো স্টেটের ওই কেউ নেই
কেউ আসেনি।
লাস্ট occasion
কেউ আসেনি। আসুন।
and my lord the amount also my lord has been disclosed if your lordship find that has been already this
Show
is
me that crystallized. compensation determined.
My lord, if your lordship kindly come to para 7, my lord, page 5.
Ashok Didi. Yes. Ashok.
বাহ, একটু বেশ এক চান্সে বলে দিচ্ছি।
Where is your representation? Any
We
representation?
have been given notice, we participated, we have
That's right. Compensation is determined,
and that was, my lord,
not paid.
kindly turn to page 24. We are called for payment. We have been directed to submit all the documents. We did it,
All right,
filed
all
it.
right, all right.
Thereafter, nothing.
The petitioner submits. Petitioners, plural. ঠিক আছে? Submit that their land has been acquired for the purpose of construction and widening of the national highway NH.
My lord,
One.
01, 01.
Huh?
01, my lord.
NH 01. Full stop.
Of 16 and 7.
Of 16 and 17. 16.
2016-17.
National highway number.
My lord, that is, lordship, that has been mentioned in his LA
Number
case
is
number,
one.
my lord.
Number
NH
is one.
Yes.
Number
NH
is one.
01. Full stop. The averments made in paragraph 7 to the writ petition shows compensation has been determined but not paid to the petitioners. While determining the compensation by the appropriate authority, the petitioner participated in the hearing and produced all the relevant documents. Full stop. Full stop. However, till date, compensation has not been paid. Paragraph. MS Monica Rai, Learned Counsel, appearing for respondent numbers
My lord, 2, 3, and 4.
2 to 4, submits that the entire compensation amount has duly been disbursed by the National Highway Authority and the same is lying at the office of the
My lord, concerned Special Land Acquisition Officer.
kindly see 8.
My lord, respondent number 8.
Lying with at the office of the respondent number 8, who should disburse the amount to the petitioner. Paragraph. Considering the above, the petitioners shall visit the office of the respondent number 8 by themselves or through their authorized representatives
Kindly, my lord, make it time bound, and there we are entitled
within a
for
period
interest.
of 10 days from date when, upon verification of all documents and records, the respondent number 8 shall disburse
The amount with
and
interest.
pay the compensation payable to the petitioners strictly in accordance with law. Full stop. Paragraph. The entire exercise as directed herein shall be carried out and completed by the respondent number 8, including making payment to the petitioners positively within a period of 8 weeks from the date of communication of this order. Full stop. It is needless to mention that while disbursing the compensation and paying the same to the petitioners, the respondent number 8 shall take all steps strictly in accordance with.
May I kindly mention, if the similar circumstance, this Honorable High Court passed an interest because they are withholding on for more than In 2019, our position has been taken.
Show me.
If your lordship kindly, 10% interest has been. তো একটাই দিয়েছে বাবা।
My lord,
Justice Arijit Banerjee.
Interest in any event, 3G5.
my lord, yes, my lord, 3H, lord, that is mentioned in 9%. my
3H5.
lord. That is mentioned in 9%, my lord. If
Why, yes, I will mention the provision.
yes, my lord.
While calculating and disbursing the compensation, the respondent number 8 shall strictly comply with the provisions of payment of interest in terms of section 3H within bracket 5.
My lord, within bracket 5. 5, my lord.
5. 3H5 of the national, আপনি কাল লিখেছেন
My lord, my lord.
National Highways Act.
My lord, Act 1956.
No, the National Highway Act 19.
National
Highways Act.
Highways Act, 1956. ঠিক আছে, কি লিখলাম একটু পড়ে দিন। Disbursing and paying. Why? পড়ুন।
Thank you.
For payment of interest within bracket 5.
But only, my lord, only one thing, my lord. This section, my lord, that has been clearly mentioned, lordship, the landed arbitrator, lordship. Lordship, as far as my knowledge is goes, my lord, here, my lord, the compensation has been determined by the competent authority, not by the landed arbitrator, my lord. This section
Doesn't matter. You have to pay interest.
My lord, my lord mentioned the sections, my lord, these sections categorically mentioned, my lord, where the amount determined under section 3G by the arbitrator is in excess of the amount determined by the competent authority. The arbitrator may award interest at 9% per annum on such excess amount from the date of taking possession under section 3D till the date of the actual deposit thereof, my lord.
This is because the
My lord,
state government.
My lord, that
my
is
lord,
my
they will have-
submission.
তাহলে এটা 3G5 হবে না,
My lord.
3H5 হবে না। কি কাটুন, আমি বলছি কি বললাম পড়ুন। না, shall calculate the interest at the rate of 8% per annum to be payable to the petitioner from the date of taking over of possession of the land,
2019.
date of taking over of possession of the subject land till the date of tendering the actual compensation to the petitioners.
I'm good.
My lord, in this case, my lord, the amount has already been deposited before the competent authority, my
that
lord.
is
No,
That doesn't matter, madam.
no, my lord, kindly appreciate one thing, my lord.
It is
If
directed
the
as phone
excess
number.
amount, my lord, if the lordship, they calculate some certain lordship, if they ask for the certain excess amount, lordship, where lordship, where no fault from the NHI, my
That
lord.
you will decide. That you will say to the respondent number 8 that I have deposited, my part is in.
They will
You
decide.
pay
Because
interest.
if the lordship's
I have
order is
said-
there, if the lordship kindly recorded this part, my lord. Otherwise, my lord,
I
because
said
we have
that
already
I have
deposited
said
the
that
amount.
respondent number 8. I have said respondent number 8 shall do it.
Government
My lord,
direction.
but my lord, the amount has to be deposited by us, lordship. Then again, lordship, they sent us.
No, if you have deposited,
Yes, my lord.
if you have already deposited, then on that date, your liability will stop. Suppose you have deposited 1 year back.
Yes.
You will not pay for 4 years interest.
Yes, my lord. But my lord, once lordship,
right.
if a lordship
All right,
only
all right.
recorded this, my lord, so that's that clarification.
I have recorded, you have already deposited.
Submission already recorded.
Yes. Next. With the above observations, with the above, on the above terms, this writ petition নাম্বারটা বসিয়ে দিন বোল্ড করে, stands disposed of. আচ্ছা, এর আগে একটা মাথায় লিখুন, since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Yes. What is this?
Next.
Next. 20?
Yes.
ওই মাথার উপর লিখুন affidavit of service filed in court today, এটা পরেরটা সেম থিং।
No, I'm coming, madam.
দেখি
তুই আছিস? তুই কার হইলে? My lord. Item number, plot number 451 and 452. These are total. One is 20 decimal,
হ্যাঁ, one is
20 decimal, another is 21 decimal, total 41 decimals. Out of that, my lord, 5 decimals have been sold to respondent number 9 and 10 private party. Now 36 decimals admittedly belongs to our family, all this family. Now they have filed a partition suit.
who filed?
The respondent number 9 and 10,
Who have purchased?
they have purchased from our,
Purchase the
from us, from our
some of the co-sharers,
co-sharers.
right?
Now, my lord, already construction has been done, position has been taken, and they have filed a partition suit. So they are not disbursing any amount for the entire amount.
Who
The
is not
government-
disbursing?
My lord, this similar national highway, respondent number, can I go? Respondent number, 8 probably.
Naturally, so
9,
long
10.
the partition suit is not decreed.
Already the nature and character of the has been said, and already there is.
Show me that they have determined the compensation.
My lord,
5 decimal land only.
no.
Huh?
Oh, I am not.
I filed a suit, they filed a written statement as well as the.
আগে আমি
Don't worry, first let me express my mind. What should I do? Yes.
এইটা দাও কত?
Show me that compensation has been determined.
Compensation determination হয়নি এখন।
Show me.
No compensation, my lord, since only this for the court case, this has not
Sir,
yet been
they have
determined.
they determined compensation or not?
No, only, my lord, because court case, my lord, why I am submitting.
Show me that document that they have not determined because of the pendency of the court case. Show me.
State can show, I can't.
File affidavit.
Yes, one. My pair also.
Considering the issue involved in this writ petition, considering the issue involved in this writ petition, this court is of the view that there is no scope for any interim order. Full stop. Paragraph. Affidavits are called for. The respondents shall file their affidavits in opposition on or before December 20, 2024. The petitioners shall file its affidavit in reply on or before January 15, January 20, 2024. The writ petition shall appear under the heading hearing within bracket land matters. Hearing land matters. Bracketer মধ্যে ওটা land matters in the monthly list of February 2024. 25. আগেরটা January 25. দিদি.
My learned friend is also, my lord, appearing.
Has sold this property. What the respondent number 9 and 10 has done, my lord, they have interpolated the deed. I am contesting the partition suit. This is my specific.
Sir, let the affidavit come.
After that, it will be no. It will be reviewed.
Affidavit of service filed.
My name was also recorded in the
In
record.
any event, my lord, only 5 decimals.
খুলতে পারলো না ঠিক মতো। National Highway
Union of India.
The state has filed a.
Madam, National Highway.
Only 5 decimals.
লিখুন।
এটা you are there.
আমি দিতাম ও ঠিক জিনিস মেটেরিয়াল দিতে পারলো না তাহলে হয়ে যেত। লিখুন the National Highway Authority in the meantime must and shall determine the compensation
Yes.
payable to the land losers out of the acquired land.
I am for the state. The difficulty is that, my lord, the award has already been declared. Now, my instruction, the difficulty is that since the partition suit is pending, he is one of the co-sharer. How much we will disburse to one?
I understand. What is the award? Award declared.
Award declared, but the,
Not to disburse, but award declared.
by it, in the instruction it says award has been declared.
Award has been declared. Sure.
My lord, may I have the copy, ma'am, so that I can Take the instructions accordingly.
Kindly see the last paragraph.
All right. কি বললাম?
কোথা থেকে দিচ্ছে?
না, না, এটা কেটে দিন। লিখুন। Mr. Tenchit Mukherjee, Learned Counsel appearing for the state respondents submit that the compensation has been determined.
No, but if you like see award, but kindly see.
Coming.
বলছি।
And the award has been made and published.
Yes.
Dated.
But only last paragraph only.
Dated.
The award has been declared in respect of an area 0.2100 acres under acquisition in plot number 451.
One second. কি বললাম? Maiden award has been made and published in respect of an area of land comprising of
0.2100 acres.
0.2100
acre.
00 acre.
Under acquisition in plot number.
In respect of acquisition of plot number
451.
451.
And an area of 0.200. There are two plots.
And another plot comprising of
0.2000.
2000
under acquisition
acre.
Of plot number 452.
In respect of plot number
452.
Mouja.
Sat Bakura.
SAT Bakura.
Jail number 673.
Jail number 673.
Police station.
PS.
Gorbeta.
পশ্চিম মেদিনীপুর
ডিস্ট্রিক্ট পশ্চিম মেদিনীপুর full stop
ডেটটা নেই তো তো দেবো
now tell me who is holding this amount
আমার
Only 5 decimals is the matter in dispute.
Who is holding this amount?
But the payment of the same have been kept pending subject to verification. That is the share area of possession of the respective parties. Because total number is 90%.
The payment of the said compensation has been withheld by the state authority in view of pendency of a partition suit.
Being title suit number,
being title suit number
1253 of 2007.
1253 of
2017.
2017.
Pending before civil judge, senior division,
pending before civil judge,
senior division,
third
court, Paschim Medinipur.
Third court, comma, Paschim Medinipur.
In respect of 5 decimals.
Stop. Full stop. Paragraph. Who is holding this amount?
But that has not been.
The state, my lord.
RS State Special Land Acquisition Officer.
Special Land Acquisition Officer, Paschim Medinipur.
Respondent number. No. Respondent number কত? Respondent number.
Respondent number. The respondent number 7 disclosing all these facts shall also file an affidavit in opposition. Full stop.
As regards the amount of the partition land involved in partition suit, kindly, because the plaint itself will not be clear.
Sir, how do we know without affidavit?
No, that is why I am saying direct them to disclose.
Not to let the affidavit.
Yes, I say they should disclose it in the affidavit about the amount of.
Right. Next.
But they ought to have annexed the plaint.
Yes.
Chalo, ঠিক আছে.
A copy of the report may be handed over.
By the way,
affidavit in opposition.
Opposition is
Should NHA also file their opposition?
Of course, respondents.
My lord.
I would have immediately directed the entire amount to be secured with the registrar. At the facts and figure you have come up.
Yes, we have got.
That's right.
Yes, I understand.
I would have. That's why I took the
Yes.
Immediately to register to the registrar general, so that it can be kept
invested
in the bearing account.
Yes, I am grateful.
Otherwise, my lord, ultimately, when the partition suit will be disposed, we don't know any appeal. Then, my lord,
That is,
This is with regard to 5 decimal, this out of 41. What the entire amount will be?
The amount pertaining to 36 decimals of land, my lord, can be reported.
আচ্ছা আসুন তো, আসুন। Considering the facts and circumstance, this court is of the view that the amount of compensation already lying with the respondent number 7
দাঁড়াও না।
needs to be secured and
my act says, my lord, we can deposit to the NHI or before the, my lord, court. Because raise
needs to be secured and to be kept in an interest-bearing account so that the principal quantum can earn interest in the meantime. Full stop. Accordingly, the respondent number 7 shall deposit the entire quantified compensation amount, quantified/determined compensation amount with the learned registrar general of this court positively within a period of 8 weeks from the date of communication of this order. Full stop. Paragraph. The registrar general, learned registrar general, then shall deposit the said amount in a interest-bearing fixed deposit account with any nationalized bank of her/his choice, and shall file a report before this court when the matter shall be taken up next. ঠিক আছে।
18, 19, 20 are asking for Union of India.
পুরো 5 মিনিট, half 5 minutes. Now,
Item number 28.
My lord, I am a petitioner, my lord. My lord, the decision, my lord,
yes,
my lord, in the year 2021, my lord, yes comes. Yes, my lord, the super cyclone, yes. And then, my lord, coastal area, my lord, highly affected. My lord, government, my lord, decided that the ring band. My lord, due to the ring band, my lord, my land was utilized, not compensation was given. I have made a representation, and thereafter, my lord, no representation was considered. And then, my lord, he filed the writ petition and served. And in the meantime, my lord, government, my lord, take the joint inspection, 23rd March 2024. And thereafter, my lord, they are waiting, my lord, result of the writ petition. My lord, kind, my lord, direct the authority concerned, responder 5.
what you want?
My lord, consider the representation.
What is the representation?
My lord, representation with compensation, my lord, due to the
Compensation for what?
utilize my land, my lord, without acquisition.
Without utilized your land for
for
what?
my ring band, the coastal area, land very adjacent to the coastal area. My lord, ring band, and on that digital utilize
no acquisition.
No acquisition. My lord, representation was made.
Briefed in this matter, Mr. Shoykot Sen is appearing for the state. He has not come to court. He has requested me to pray for an adjournment. I'm only praying for not today.
Not come to court. Passed over for the day.
Mr. Poddar, Mr. KD Poddar is appearing with the petition, and I'm praying for not today only, my lord. He is in code number 22.
Passed over for the day.
Yes, my lord.
But I am for the petitioner. The affidavit of service is not ready as because that admin record is not present. But it's appearing, service has been completed.
State is appearing.
My lord.
Private respondent is there.
No, my lord.
What is the matter?
Matter is, my lord, for the purpose of water purification scheme under the PHE department. Under the PHE department for water purification scheme, some land is required for construction a tank, overhead tank. My lord, for that, your petitioner was called by the PHE department.
Land has been, tank has been constructed.
No, my lord. The boundary wall has been constructed
without acquisition.
Without acquisition.
Where is the representation?
My lord, representation is page 34 onwards.
So direct purchase policy.
We have taken step for direct purchase policy. They have given his consent, my lord.
One second. 30?
34 onwards.
Give me one. Don't give onwards.
34, my lord.
34. Very well. And I record that he's submitting. The steps have already been taken for direct purchase policy. Yes. Consent obtained.
The consent obtained, my lord.
Complete that.
Process, my lord. Yes.
Complete that within 6 weeks, 7 weeks. Complete that.
With compensation. With compensation.
Direct. Direct purchase policy itself is a compensation.
Right.
At the market rate, it will be purchased.
Right.
That is itself compensation.
Yes.
Ashu. The petitioner, affidavit of service, what's your name?
Tanmay Khan.
Mr. Tanmay
Khan.
Khan. Learned advocate appears for petitioner. Mr. Priyobroto Bhattabal.
For the state respondent, all the respondents, all the state.
Learned State Council appears for the respondents. Paragraph. The petitioner submits that.
Only when I'm not for 4, my lord. 4 is the Jila Parishad. I'm not appearing for the 4 one. Except
respondent number 4. Priyobroto Bhattabal ki bollam? Respondents except respondent number 4.
Yes.
Paragraph. None appears for respondent number 4. Respondent numbers 4. Number 4. Paragraph. Petitioner submits that without acquiring the plot of the petitioner, comma, the state has utilized it for public purpose, and the overhead water tank is under construction on the said land.
Tank has not been under construction, only boundary wall has been constructed. No point tank has.
কি বললাম? And state is in the process of utilizing.
Yes.
In the process of utilizing the land of the petitioner. In the process of utilizing the land of the petitioner for the purpose of construction of an overhead water tank. Full stop. Boundary wall has been constructed surrounding the land. Full stop. The petitioner submitted its representation dated
8/9/2023.
September 8, 2023, September and October. October 9, 2023.
There is two representation.
Annexure P3 at page 34 to the writ petition. The same has not been, the same has not been disposed of. Paragraph. Land State Council on instruction submits that the land of the petitioner, though has not been acquired, that is being utilized for public purpose by the state. Full stop. The state has already initiated process under direct decap purchase PCAP policy. PCAP. এটা bold হবে, direct purchase policy. কি বললাম? The state has though has not been acquired but is. And the state, but and the state has direct purchase policy কতটা bold, capital বলে যেরকম বলেছি. The petitioner has also given its consent, due consent.
Yes, sir.
So that the state can proceed with the direct purchase policy. Paragraph. In view of the above, who shall be directed? Tell me.
But this one for a secretary, not 24 months. Jila
Respondent number?
This one 4 months.
In view of the above, the respondent number 4 is directed to take steps and forthwith complete the direct purchase, forthwith complete all the formalities and process under direct purchase policy of the state, and then after carrying out all the necessary documentation, shall pay the purchase consideration to the petitioner strictly in accordance with law. Paragraph. The entire exercise as directed herein shall be carried out and completed by the respondent number.
Actually 6 months, my lord, because a lengthy process for 6 months.
Respondent number.
So 4, my lord.
4 positively within a period of 6 months from the date of communication of this order, which shall include the payment of purchase consideration to the petitioner without any default. Full stop. Default and delay. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. On the above terms, with the above observations and directions, this writ petition, bold WPA 3059 of 2024, stands disposed of without any order as to costs, comma, without any order as to costs. Next.
I am appearing for the petitioner. Matters relates to encroachment, Lordship. Matter relates to encroachment. The Lordship Annexer P4, page 31.
Corrected order?
I have corrected it.
Show him.
Yes, so, my lord, the last one yesterday is given the order, my lord. Similar order may be possible.
আসুন এটা দিয়ে দিন বাস ওকে ওর সঙ্গে পাঞ্চ করে মাথার উপর অ্যাফিডেভিট অফ সার্ভিস ফাইলড ইন কোর্ট টু ডেজ টেকেন অন রেকর্ড আর দরকার নেই আমার annexure come on দেখি you have corrected
P4
you have corrected
I have corrected annexure
Kamal Mishra আর প্রিয়ব্রত বটব্যাল Kamal Mishra for the petitioner প্রিয়ব্রত বটব্যাল for respondent numbers.
So, Lordship, the respondent number, the government respondent 1, 2, 3, 4, 4, 5, 6, 7.
1027.
127.
And private respondents?
8, 9, 10. Nobody had appeared it. I have submitted.
None appears for the private respondent numbers 8
8,
to
9,
10. 8 to 10, comma, despite notice.
Lordship.
দেখুন অসুবিধা হলে জিজ্ঞেস করবেন
I'm left by Mr. Bondobadhyay.
Lordship, every person will get an opportunity to appear before the authority concerned to make the submission by virtue of this Lordship's order. Nobody will be affected, nobody will be deprived of getting any chance to make the submission before the authority concerned.
এখানে প্রাইভেট রেসপন্ডেন্ট কে নোটিস অ্যাপিয়ার করতে বলা আছে তো দেখিনি
হ্যাঁ every person. Already the BLR will serve the notice all the private respondents prior to holding an inquiry. Every person will remain present at the time of holding an inquiry. Lordship, every person will get the chance. Nobody will be affected. Lordship, it is reflecting Lordship's order.
You have checked the respondent numbers?
Lordship, 8, 9, 10.
No, that's all right. Respondent number 4.
Respondent number 4, the respondent number 6 is the BLRO. Lordship directed it. It
And
is
4,
reflecting
4,
from the
4.
and respondent number 4, assistant engineer.
Right.
6 and 4.
You have checked though?
I have checked.
That's all.
6 and
so
4.
that no further typographical
No.
mistake.
6 and 4. BLRO 6 and 4.
All
assistant
right,
engineer.
all right.
I'm grateful to you.
All right.
I'm grateful to you.
Yes.
In this matter, the petitioner was provided with a sand block in the
Where is the other side?
other side, Mr. I have tried to contact over telephone. He's
Passed over for the day. Next.
provided back to for the petitioner.
No, the statement.
So he's the affidavit of service. Lord, the land of the Lord, the state government.
Yes, yes, yes. Yes, Junior. Yes.
Lord, the state government in the year 1950 acquired about 493.2 acres of land. Now the land belonged to one Bhavataran Sinha. The petitioner herein is the
Take microphone properly. Yes. Be louder.
Now, my lord, the petitioner herein is the daughter-in-law of Bhavataran Sinha. A land acquisition case was initiated in the year 1950-51. 493.2 acres of land was acquired. Notices were served. The notices are annexed at
Compensation paid or not?
No, compensation not paid, my lord, till date. No assessment.
Not paid
no
to anybody.
Nobody.
Land acquisition case of 50-51, my lord.
So what? You not pay compensation?
We have to
500
take
acres.
my instruction. Without instruction, I cannot say, my lord. Whether compensation is paid or not, we have to, my lord, go through the record, my lord.
But-
Without instruction, we cannot say.
Well, let them file a report on the petitioner herein is the octogenarian, my lord.
Huh?
The petitioner herein is the
Where is your representation?
my lord, at annexure P4, my lord, last page 33.
Consider that.
That can be
This is the last representation, my lord.
Page 33.
Yes.
Huh?
Yes, my lord.
Which respondent shall consider? Mr. HON'BLE, Special Land Acquisition Officer.
Yes. Yes, this one of 5.
5, my lord.
5. Ashut, take microphone.
The petitioner is about 89 years old. But my suggestion is, my lord, let them file a report. Let them file a report disclosing, my lord, if award is passed, when it was passed, because I made representation, I made application under RTI, no reply was given. If award is given, to whom it was given? If not given, what is the reason? My lord, this lady, my lord, but he is fighting for long. Ultimately, my lord, he approached before your lordship, my lord. Let them file a report. My lord, we should know, my lord.
No fruitful purpose will be served, I tell you.
Then, my lord, if your lordship.
What I was thinking, let him attend, let her, through her authorized representative, attend the hearing. There, every record shall be produced, right? On the basis of that, they will pass a reasoned order. And I will say, if the compensation is payable to the petitioner, and I will also direct all other interested parties.
Yes.
All other interested parties.
Yes.
Who shall be there.
Yes.
Right?
Within a stipulated period.
Of course. So that it can, but the thing is, how do they know who are the interested parties? Their record will speak. Acquisition record will speak. Who are the owners?
Records, notices are there. Notices are in favor of my father-in-law.
Father-in-law.
My father-in-law. My husband died now. So I am the legal heir.
Because this affidavit, if I call for, after 2 extension, it will arrive 51 land acquisition case. It will arrive not before 2029.
Yes, ma'am.
When I will have only 4 years left. So don't do that. 3-4 years left, nothing. Go back. Ashun. The petitioner contends that, no, petitioners. Who are they?
Petitioner number 1 is the daughter-in-law, and petitioner number 2, 3, and 4 are the sons of petitioner number 1.
The petitioners claim to be the legal heirs of one
Bhavataran Sinha.
Spell out.
P-H-A-B-A-E-A-R-A-N. Sinha. S-I-N-H-A.
Since deceased. The land of the deceased was acquired for public purpose. Under land acquisition case number 160. কোন পেজে?
Paragraph 4, my lord.
Under land acquisition case number
166 of 5051.
No.
Paragraph
166.
Yes.
Under land acquisition case being bold korun capital L full stop capital D full stop number in cap LD number 166 of 1950-51. Full stop. The petitioners claim that the compensation has not yet been paid either to the deceased during his lifetime or to his legal heirs till now. Full stop. The petitioner number 1, Shanti. No, Shanti to লিখবেন না. The petitioner number 1 has submitted a representation dated December 1, has submitted a representation on December 1, 2023, annexure P4 at page 33 to the writ petition before the respondent number 5. And the same has not yet been decided. Paragraph. Mr. Potterbal, Land State Council, Priyobroto Potterbal, you are alone.
I'm led by Mr. Soumitra on the
Mr. Priyobroto Potterbal, where is he?
But he's engaged in Corona
He's
39.
come to court.
Yes, yes, come.
Mr. Priyobroto Potterbal, Land State Advocate, along with led by Mr. Soumitra Bandyopadhyay, Land State Council, appear for respondent numbers.
All the respondents.
Respondents. Paragraph. In view of the above, the respondent number 5, upon issuing a prior hearing notice of at least 7 days to the petitioners, and after affording them an opportunity of hearing, shall decide the said representation dated December 1, 2023, annexure P4 at page 33 to the writ petition by passing a reasoned order in accordance with law. Paragraph. It is needless to mention that the petitioners may participate in the hearing through their duly authorized representative. Paragraph. The entire exercise shall be carried out and completed by the respondent number 5 positively within a period of 6 weeks from the date of communication of this order. And the reasoned order shall be communicated to the petitioners and also to their representative, authorized representative, positively within a further period of 2 weeks from the date of the said reasoned order to be passed. Paragraph. While deciding the issue and passing its reasoned order, the respondent number 5 shall refer to and disclose all the relevant materials to show when and how the compensation has been determined, and if paid, to whom, and if not paid, the reason for same. Full stop. Paragraph. It is made clear that this court has not gone into the merits of the claim of the petitioners.
But if they find that we are eligible for the compensation,
coming. Listen. কি বললাম? This court has not gone into the merits of the claim of the petitioners. and the petitioners shall be at liberty to urge whatever points they wish to urge by relying upon whatever records and documents they wish to rely upon before the respondent number 5, but the same shall not travel beyond the scope of the said representation dated December 1, 2023, as referred to above, comma, as referred to above, full stop. Paragraph. In the event it is found that the petitioners are eligible to receive the compensation, then upon compliance of all the necessary formalities, the compensation shall be disbursed and paid to the petitioners by the respondent number 3 and or any other appropriate state authority in accordance with law, positively within a period of further 4 weeks from the date of the said reasoned order to be passed. Paragraph. It is made clear that this order shall not create any right or equity in favor of the petitioners if they do not succeed to their claims strictly in accordance with law before the respondent number 5. Paragraph. In the event it is found that the payment of compensation is long pending, payable to the petitioners, then the respondent number 5 and or the appropriate state authority shall pay the same to the petitioners along with interest at the rate of 5% per annum from the date of taking over possession till the date of actual tendering of money to the tendering of compensation to the petitioners. Paragraph. Since affidavits are not called for, the allegations made in the writ petition are deemed not to have been admitted by the respondents. Paragraph. The time frame directed above stands mandatory. Paragraph. With the above observations and directions, this writ petition bold WPA 5216 of 2024 stands disposed of, comma, without any order as to costs. These affidavits will not serve any purpose because 51 land acquisition case, inevitably 2 to 3 extensions.
Notices were served in 70s.
Next.
For the petitioner, I am appearing on behalf of respondent number 529.
Private respondent.
529.
Led by?
Mr. Chondi Choron.
Yes.
My lord, in this matter, the private respondents are trying to correct the record of rights on the basis of an alleged order.
Correct the record of right.
Yes.
Let me see your prayer.
My lord, I am not that on the not that prayer, my lord. Kindly see.
Let me see your prayer.
Yes.
Read on.
It in the nature of mandamus commanding the respondents to set aside and or reverse and or cancel the alleged order dated 4/11/1975 passed by the respondent number 3 case number 20 of 1975. Nature of mandamus commanding the respondents to declare the case number.
Show me the impugned order. 4th November.
Yes.
1975.
Yes.
Show me.
Page number 22.
22.
No signature, no designation.
Page number 22.
22.
What is this?
This is the expense of alienated land at on the basis of, but no signature, no stamp, no designation of the authority who has passed this order is available. That is why the petitioner filed an application for.
First, you satisfy me that 75 order you can challenge in 24.
Yes, my lord. They are now in 24. They have initiated proceeding for correction of the record of rights.
Who received?
Private respondents.
You say you are the owner.
Yes.
You are the owner?
Owner. They are saying that.
What is 75 order?
75 order for restoration of alien land, my lord.
In whose favor?
In favor of the private respondents, whose my predecessor, my lord, my lord, predecessor, my lord, sold the land to the petitioner.
Whose predecessor sold the land to the petitioner.
Petitioner.
So you have stepped into the shoes. You have stepped into the shoes of the private respondent.
Yes.
Right?
Yes.
When you purchased?
Purchased no long ago, my lord, 19.
Prior to 1975.
72.
What you were doing so long?
No, I have no fault. They are now they have initiated proceeding for correction of the record of rights on the basis of this order.
On the basis of this order, where they have initiated proceeding, where they are claiming record of
BLRO. Then in action, my lord, LRTT directed to consider the representation. Then they are now trying to correct.
To consider the representation. Whose representation?
Representation private respondent.
Private respondent. And then you came to know of 75 order. You have purchased the land prior thereto.
Yes.
How can you challenge 75 order?
Yes, my lord. That is the question, my lord. But they are now trying to give effect of the order of 75.
That's right. Where is the wrong?
In 24.
They may, because they have a right.
But
This order is there.
But there is a provision, my lord, for preparing appeal against this, say, 75 alienated restoration of alien land.
Sir, short question. You satisfy me first. A 75 order can be challenged in 24.
Yes, my lord. They are now
after 50 years.
How the order can be implemented after 50 years? That is my question.
Why not? Why not?
No, then, my lord, I have applied for certified copy of the order. I have applied for certified copy of the order. My lord, I cannot annex, my lord. They have said that no such documents is available in the office.
That's right.
No such available documents is available.
Then how could you get this order? How could you get this order? Annexure
This order, my lord, they have annexed in the original application filed before the Bengal LRTT. Land Reform Tenancy Tribunal.
How can you maintain this writ petition after 50 years?
I will tell one thing.
My lord, kindly.
My lord, the order was passed. It was complied with. I was asked. It was complied with.
Complied with?
Yes, because I was asked to make payment. The amount being paid, and all along, my lord, the petitioner's father was the original transferee. My client's father was the transferor. Yes, the land was admittedly held by the authority concerned as transferred in distress. So the order was passed in my favor. The order of transfer was cancelled. So I got the land back.
One thing. Equally, if you have executed the conveyance, your predecessor, without seeking a cancellation thereof, how can you come for correction of record of right?
It is cancelled, your lordship.
By the civil court?
No, the authority concerned.
Authority can cancel a deed.
That is the order, your lordship.
75?
Yes, lordship. That is it.
No signature, no designation.
It is there. Signature is there.
No.
For
If
11/1970.
if a sale deed is executed, conveyance is executed, and without the civil court, any other authority can cancel it.
No, my lord.
My lord, will come forward, your lordship. My lord suddenly came. There's a provision, your lordship. We need to come because the old act will come up, your lordship. Can we fix it up tomorrow or any day? Will come up.
No.
Yes, lordship.
If
my lord, that is the Restoration of Alienated Land Act.
In that act, my lord, there is a restoration of alienated land act.
That's
There
right.
is a provision to cancel if in the prohibited period, if anybody, my lord, executed any transfer land, then that will be cancelled and returned back to the original owner.
That's what
That is the provision. Restoration of alienated land act.
But sir, one thing, what is
1973.
troubling me, this is an order of 1975.
Yes, my lord. That is the
Right. Now the writ petition is filed after 50 years.
That is there is a provision of appeal. They have not come. They have not any jurisdiction to come here. There is a provision of appeal.
No appeal was preferred. The
No,
order
my lord,
was,
the petition is not maintainable.
the order was acted upon by the parties.
How I said,
I paid the money according to the orders. I paid the money was accepted by them.
my lord,
Thereafter, nothing
Oh,
really-
you have returned the cell consideration.
Yes. Pursuant to the order of the
Right.
learned authority, we returned the amount.
my lord, the petition is not maintainable.
It's nothing.
I'm keeping the
Coming after
question of
70
maintainability open. Ashun.
As
this condition is mentioned. Yes, it was mentioned. The order itself speaks of that.
An order which is impugned to this writ petition is dated November 4, 1975. Full stop. The writ petition is filed almost after 50 years.
Sir, this is the premium. This is not maintainable as because there is a provision of appeal. How
I am recording, sir.
And now, my lord, I am according to your lordship, I am bound to give the affidavit in opposition.
Yes,
That is-
without I will keep all those points open. You will take those points. You will take those points. Ki bolla? Because if I relegate him to appeal, which means I am not accepting the writ petition on merit on the ground of alternative remedy. But if it shows from affidavits that this writ petition is totally frivolous, then it can be dismissed here by this court only on affidavit, even without granting him a liberty to go for appeal. What he is saying that this order was passed in 75. Pursuant to this order, his predecessors, the seller,
my lord,
have already returned the sale consideration.
My lord, that is a provision of that restoration of alienated land act. Oh, where is the restoration of alienated land act? So, my lord, please show.
That is why I am saying.
You are coming without any, my lord.
No.
My lord, as because there is a provision. So, my lord, there is no any giving the affidavit in opposition, other thing, my lord. As there is a provision restoration of alienated land act. There is a provision. My lord, he wants certified copy of the order. My lord, your lordship passed the order. We must give the certified copy of the order.
Yes.
My lord, why this writ petition is
all these points in your affidavit?
My lord, why this one writ petition? Why pending before the Honorable High Court, which is not maintainable, and according to the provision, he now wants, my lord, he now wants to file appeal to get the certified copy. I must give the.
I will not grant him that leave after 50 years. If I find from affidavit.
My lord, from affidavit, after that, my lord, another day, we must take another 1 hour and for the petition.
Without the affidavit, I will not, after 50 years, I will not do anything. Even dismissal, I will not do. After 50 years, I will make it very clear. This pendency of this writ petition shall not affect anything.
My lord, Father, your lordship, they moved before the Honorable Learned Tribunal.
I have to know all this on affidavit. Unless affidavit comes.
They suppressed it. They have suppressed it.
Then you have to disclose it through affidavit.
What's the act? Certificate copy. I want certificate copy.
কি বললাম? 1975. No, ওর সঙ্গে paragraph ওর সঙ্গে. The writ petition is filed almost after 50 years. Paragraph. Mr. Lutful Haq, learned advocate, appears for respondent numbers
5 to 9.
5 to 9. And Mr. Chondi Charan De, learned additional government pleader, appearing for respondent numbers
1 to 4.
1 to 4. Both have taken the point of maintainability of this writ petition. Poster. Learned additional government pleader further submits that the relevant statute prohibits filing of this writ petition.
Yes, my lord, there is a provision as
Poster. And there is a provision for statutory appeal.
yes, ma'am.
Poster. Paragraph. Additionally, Mr. Lutful Haq, Learned Counsel, submits this writ petition has been filed in cross suppression of material facts. Poster. Paragraph. Considering the above, this court is of the view that there is no scope for any interim order. Poster. Paragraph. Affidavits are called for. Paragraph. The respondents shall file their affidavits in opposition on or before December 20, 2024. Affidavit in reply, if any, thereto shall be filed by January 20, 2024. 25. January 20, 2025. Liquid 25. The writ petition shall appear under the heading hearing bracketed land matters in the monthly list of February 2025. Paragraph. Pendency of this writ petition shall not create any right or equity in favor of the petitioners in any manner. Full stop. The maintainability of the writ petition, the point of maintainability of the writ petition shall be heard first on the next day.
Well, as my lord, he wants certified copy. Your lordship can give him a certified copy.
No, no, his prayer is setting aside, sir. Kindly look at it. Kindly look at it. Kindly look at it, sir. Prayer.
Prayer. Whatever prayer, my lord, that is a very simple case, my lord. That is,
sir, with this prayer, if I allow certified copy, and if the petitioner chose to challenge the order, the order said that the relief claims otherwise. Reliefs are claimed otherwise. Kindly see the reliefs claimed in the writ petition. Kindly see the relief.
Yes, my lord.
Relief is always mandamus, setting aside.
My lord, he is an advocate. He wants everything. He has that right.
Yes. আর কিছু করতে হবে আসছে
My milord has been.
tomorrow. Motion top.
Milord, I am also serving copy on the government
And
pages also.
affidavit of
And
service.
my lord, I shall. In course of the day, I am doing that. I am indebted, my lord.
Motion top. কালকে motion top.
So, my lord, today they are with mic, they are announcing in the locality to vacate it, otherwise it will be demolished. I have got that video. They are now, last time they gave us a notice. Then it was squash. This time they have not given us a notice. They are just by word of mouth. They are doing it, my lord. Therefore, my lord, I bothered my lord.
Motion top. কালকে.
I'm grateful, my lord. Great.
You
Lord, I appear for the KMDA, respondent number 5 and 6. Affidavits are complete. The matter is ready.
Passed over for the day. ডাকুন।
I am for the state money. ওটাই থাকবে না, কেউ দেখেনি, আমিও দেখেছিলাম না।
হঠাৎ করে
হ্যাঁ দাঁড়ান 1 মিনিট। হ্যাঁ ঠিক আছে।
Lordship, item number 203, Lordship. I am for petitioner, Lordship, led by Mr. Biyani, Lordship. He is appearing on virtual, Lordship.
Yes.
Lordship, item number 203, Lordship. I am for petitioner, led by Mr. Biyani, Lordship. He is on virtual.
Who is for the respondent?
Lordship. I think, Lordship, no one is appear, Lordship. Lordship. Lordship, Mr. Oyon Banerjee was appearing for Lordship state respondent, Lordship, but there was a direction to filing, Lordship, opposition, Lordship, but no opposition filed. No opposition filed till today, Lordship.
Till today. No opposition filed.
No opposition filed, Lordship.
আসুন। Mr.
Soumojit Ghosh.
Your name?
My name, Lordship.
Soumojit Ghosh, learned advocate, appears for the petitioner. মাথার উপর লিখুন, this is a hearing matter. Paragraph. Despite directions, no affidavit in opposition has been filed. Paragraph. In view of the above, for the ends of justice, peremptory opportunity is granted to the respondents to file affidavit in opposition.
But if your lordship should allow me to appear online.
December 20, 2020.
Lordship, I am led by Mr. Biyani. He is on virtual.
Will your lordship allow me to appear online? Because my lord, I'm sorry, I'm suffering from an infection in my leg. That is the reason. But I appear for the petitioner.
No problem.
But I appear for the petitioner. Lordship
affidavit opposition not filed.
That's right. And if your lordship, my lord, there is some urgency, if your lordship allows them, gives them a peremptory time subject to your lordship's pleasure.
কি বললাম? না না, ওর প্রথম ওর নামটা Mr. Soumojit Ghosh, learned counsel, led by Mr. Nayan Behani, learned counsel, bracketed through virtual mode. Appear for the petition. December 20, 2020. Affidavit in reply, if any, thereto shall be filed by January 20, 2024. The writ petition shall appear under the heading hearing bracketed land matters. Land. Jai likhen. In the monthly list of February 2025. Oh, আগেরটাও 5 হবে January 2025.
Malad, will it be your lordship's pleasure to make it a peremptory direction?
Inform your senior.
Lordship, I will inform.
I'm sorry, my lordship.
That is already there in my order.
I'm deeply obliged. I'm deeply obliged.
Grateful, Lordship.
So, I am for the KMDA, my lord, respondent.
Passed over for the day.
May I file my affidavit? One line would be recorded.
Very well. None appears for the petitioner, nor any accommodation has been sought for. Eta মাথার উপর লিখবেন. This is a hearing matter. Paragraph. On the prayer of Mr.
Satyajit
Talukdar, learned advocate, appearing for respondent number
5, KMD.
5. Time to file affidavit in opposition
ready?
stands extended till today. Full stop. The affidavit in opposition filed today in court is taken on record.
It's a counter affidavit. It's a counter affidavit.
Counter affidavit? You said opposition?
No, counter affidavit.
Opposition file?
Yes.
Reply file?
Reply file. Thereafter, my lord, they are pursuant to the direction of by the court, my lord.
Counter affidavit. Affidavit in opposition na kore counter affidavit.
Because there were some application.
Good
Lordship
stuff.
was pleased to direct them to file a composite supplementary affidavit, and we were given liberty to. Is against the can.
চেষ্টা করছি নিতে না এলাম কি করা যাবে চলুন
After the affidavits were completed,
alright কি বললাম
we can application.
you have filed your opposition কি বললাম
My lord, that point.
হ্যাঁ
My lord, today I am not coming with that file. As because I will.
no but have you filed
My lord, if the file is not with me, my lord.
how will you say ঠিক আছে
Only for that.
কি বললাম আচ্ছা এবার লিখুন মিস্টার চণ্ডীচরণ দে an additional government pleader appears for the state respondents. Paragraph. Petitioner shall be at liberty to file its rejoinder to the said counter affidavit.
No, they have filed pursuant to your lordship's leave, my lord. They have filed a composite supplementary affidavit, as there were 3 supplementary affidavits, and we were given to.
Very well. চলুন হয়ে গেল তারপর লিখুন না দরকার নেই চেপে যান ছেড়ে দিন লিখুন the writ petition shall appear under the heading. What you are looking on your mobile? Who is he? ছবি তুলছে না ভিডিও করছে কিছুই বোঝা যায় না Hearing Calcutta land matters in the monthly list of February 2025. Next.
25.
That in this matter also.
I'm for the state.
In this matter, Mr. Putip Chatterjee is appearing on behalf of the petitioner. And last occasion, your lordship was pleased to direct to file affidavit in opposition. But till date, the opposition has not yet been filed.
Opposition not filed. Serial number?
205.
205?
Number to the.
205.
No.
Case number.
WPA টা একটু বলে দিন তো
15012. No, I am not.
Opposition not filed. আসুন Mr.
Gautam Banerjee.
Gautam Banerjee. You are Gautam Banerjee. Mr. Gautam Banerjee, learned advocate, appears for the petitioner. Paragraph. মাথার উপর, this is a hearing matter. Paragraph. None appears for the respondents, nor any accommodation has been sought for. Paragraph. Learned advocate for the petitioner has informed this court that despite direction, no affidavit in opposition has been filed. Paragraph. For the ends of justice, time to file affidavit in opposition stands peremptorily extended till December 20, 2024. Paragraph. Affidavit in reply, if any, thereto shall be filed on or before January 20, 2025. Paragraph. The writ petition shall appear under the heading hearing bracketed land matters in the monthly list of February 2025. Next.
For the petitioner, my lord. আপনি আছেন কোনটা 206 last occasion your lordship directed me my lord, to file their opposition, my lord. Till date they have not filed.
Till date not filed.
Kindly see the impugn order, my lord.
Not
My lord, my
required.
claim was
Till date no opposition filed.
Today we have missed the brief, my lord. Kindly
So
pass it.
what? Opposition not filed, miss the brief. How
Miss
does
the
it
list,
matter?
ma'am, miss the list, ma'am.
order was passed 15 July, my lord. 15 July order was passed, my lord. Directed them to file opposition, sort of opposition, because my lord, two plots I they were considered one plot.
ঠিক আছে, শোনো না, যদি আমরা থাকি আমরা দেখে নিচ্ছি, ব্রিফটা আমাদের আর নেই আজকে।
Mr.
অপোজিশন আমরা টাইম
Lal Ratan Mundal.
This is a hearing matter. Paragraph. Mr. Lal Ratan Mundal, learned advocate, appears for the petitioner. Paragraph. On the prayer of Mr. Soumitra Bandyopadhyay, learned State Council, appearing for the state respondents. Time to file affidavit in opposition stands peremptorily extended till December 20. Full stop. If the opposition is not filed by other respondents, the same direction shall bind them. Paragraph. Affidavit in reply, if any, thereto shall be filed by January 20, 2025. Hearing land February. Next.
Mr. Amit Kumar Pan is appearing on behalf of the petitioner, lordship. Mr. Amit Kumar Pan is appearing on today, lordship. He could not come to the court, lordship.
Passed over for the day.
Lordship. By Mr. Abhishek Guho, I'm praying for a short passover.
Passed over for the day. একটা টেকনিক আপনারা কেউ কিছু বললেন না। দেখুন টেকনিক্যাল ভুল আছে, কি বলুন তো, এখানেই তো লিস্ট ইজ এক্সস্টেড। তাই হোক, চুপচাপ ডাকতে থাকো, আমি দেখতে কিছু করবো না। মোশন ডাকবেন, ল্যান্ড না, এটা কি মোশন মান্থলি লিস্টই তো, সেটা তো মান্থলি লিস্ট থেকেই হলো। এবার আপনি মোশন ডাকুন, মোশন ডাকুন। আর শুনুন, ওইটা দিদি, ওইটা আমার সঙ্গে কথা বলে নেবেন, ওটা ইনক্লুড করে দেবো আজকে। আপনি আমার সঙ্গে দেখা করে কথা বলে নেবেন, এখানেই আমি ইনক্লুড করবো।
Number 42.
41 অব্দি আমরা ডেকেছিলাম, তাই তো? হ্যাঁ, ফার্স্ট ওভার। ডাকতে থাক, ফার্স্ট ওভার।
Petitioner, senior counsel is absent today. Senior counsel is absent today. Therefore,
Who's senior counsel?
Somik Ghosh.
Somik Ghosh, senior counsel.
Yes, yes. But I'm playing one with 10 better. বুঝতে পারছি না। না, না,
আমার লিস্টটা দিয়ে দিন। আমার লিস্টটা দিয়ে দিন। কোথায় অমিবাবু কোথায় গেল?
তুমি তো বলে আমি কি করবো? জজ সাহেব একটা অর্ডার দিয়েছিল আইডেন্টিক্যাল। সেটা বললে হবে কি করে? এটা কি অর্ডার আমি কি করে জানবো? এটা আমার কাছে নেই।
কি মামলা তাই জানি না।
হ্যাঁ। But without acquisition, utilize the land. And
So direct purchase policy.
yes, they have already representation is there. No. They have already obtained the consent of my client for direct purchase.
আজকেই তো একটা অর্ডার দিলাম, কত নম্বরে?
Yes, but identical matter, your lordship, I have moved some self proceedings. দেখাচ্ছি just
ওটা কি তোমার একটা পকেট থেকে আটটা দাও।
দেখি দিন।
এদিকে ব্রিফ ছিল না, এদিকে পকেট থেকে অর্ডার বেরোচ্ছে।
অর্ডারটা ছিল পকেট।
ওটাই তো আসল।
যে জিনিস একখানা তুই ব্রিফটা দাও না, অর্ডারটা পকেটে নিয়ে এসছো না।
ছিল পরে
আটটা দাও।
দেবো আমি তো বলি
Requisition or acquisition?
Nothing has been done.
In this matter, land was acquired.
No, they have utilized my land without due process of law. No acquisition.
No acquisition, no requisition.
Nothing. Then obtain a consent from my client for direct purchase. Thereafter sitting tight. And I made a representation. Identical matter, my lord, I have moved and your lordship passed.
কি বলছে? তো রিপোর্ট ফাইল করতে বলেছে।
Yes. They have to let them file a report. What is the present position?
You have given consent?
Yes. Already we have given a consent.
The কাগজটা দিই।
আমি সেটা বলে দেব।
অর্ডার পেয়ে যাবে।
দেখো না, তুমি দেখো। সামনেরটা।
Show me your consent.
My lord, page 21. Page 21, annexed P1.
That's your consent?
Yes.
Yes. Page 21.
Starts. But there are 21 petitioners, my lord. Similar prayer.
কি করা যায়? বিএম করলে হবে?
Court fees to be paid at least.
কি বলছে?
They are commissioned to pay court fees, deposit court fees.
They are not paying money and demanding court fees.
It's a case of 86, 87.
But they have utilized.
After 37 years, they're coming to this honorable court. এটা কি অর্ডারটা দেখো।
ডেটটা কবে? পেজ 21 এর ডেট কবে?
ডেট দাওনি তো? একটাও ডেট দেয়নি।
না, ডেট
একটাও ডেট দেয়নি।
রিসিট আছে।
আরে বাবা, এই তো দেখো না, জজ সাহেব এটাই বলছেন। জজ সাহেব এটাই বলছেন, তোমার ডেট নেই। দেখো রিসিভ একটাও নেই। রিপ্রেজেন্ট তো পরে 2/11/23। ডেটে তাহলে জজ সাহেবের পাতাটা দেখাও।
ডেট কবে?
They have also made a representative page 67, my lord.
আমি দেখেছি। 43 তেও আছে।
Yes, my lord.
প্রেজেন্টেশন 43 তেও আছে। আসুন।
তোমার brief যদি miss
Affidavit of service কই?
জজ সাহেব কি বলছেন?
Affidavit service, my lord, actually entire papers is lying with my senior.
Your senior?
Yes. The senior, my lord, he has not.
কি তোমার
I
senior?
think he has not come today. That's why Well, I am facing the
তোর সিনিয়র
difficulties.
কে?
Otherwise, I have solved everything because other side is here.
সমন্ধা তোমার সিনিয়র কে? তোমার আবার সিনিয়র কে? হ্যাট, তোমার আবার সিনিয়র কে? তোমার তো
There are 21 individual writ petitioners. Only one court fee has been paid.
If a lot of so desires, my lord, I have to deposit, my lord. I have nothing to do with this.
Subject to payment of the balance court fees by the rest of the petitioners, this order shall be effected. কি কষ্টের ব্যাপার বন্ধু, যদি কোর্ট ফি না দেয় অর্ডারটা থাকবে কিন্তু অর্ডার এফেক্টিভ।
If I own deposit the deficit court fees, only PD.
আমি তো জানি আমি কি বললাম।
My lord, if I
The petitioners
yes, my lord.
contend that their land has been utilized long back for public purpose by the state without acquisition or requisition. Full stop. The petitioner has not been paid any compensation. Full stop. The petitioners submitted a representation dated November 28, 2023, Annexure P2 at page 43 to the writ petition before the state authorities, but the same has not yet been dealt with. Paragraph. Referring to the documents, Annexure P1 at page 21 to TO2, 42. Learned counsel for the petitioner submits that the state has already obtained consent from the land losers to implement bold direct purchase policy in accordance with law. Fine. Mr. Bandyopadhyay, which respondent?
all respondent. Respondent number 4, my lord, will consider.
Yeah, court fee.
দেখো না দেখো না
Paragraph.
কালেক্টর দেখো না।
Oh, correct.
Yes.
Who shall complete? Who shall complete?
Respondent number 4
Four.
Oh, yes.
বললাম
In view of the above, the respondent number 4 is directed, after verifying all the records, to implement, execute, and complete the direct purchase policy
মানে if it is not already paid.
in the event compensation has not already been paid to the petitioners or the land losers. The policy shall be implemented strictly in accordance with law. Paragraph. The entire exercise shall be carried out and completed by the respondent number 4, including making payment to the petitioners in accordance with law, positively within a period of 6 months from the date of communication of this order. Paragraph. It is made clear that the direct purchase policy shall only be implemented or in the event the compensation has not yet been paid to the petitioners or the land users. Full stop. Paragraph. It is also made clear that this order shall not create any right or equity in favor of the petitioners if they are not eligible to receive the benefit of the direct purchase policy of the state, strictly in accordance with law. Paragraph. Since affidavits are not called for, The allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition bold WPA 8892 of 2024 stands disposed of without any order as to costs.
Okay.
Thank you.
Yes.
Good.
I'm getting.
Court fee?
What is the, what is this order? নাম আছে ওই একটাই স্বপন কর হাইকোর্টে একটাই
ভয়ঙ্কর
স্বপন কুমার কর
ভয়ঙ্কর
মারাছে
শান্তিদার পলিটি ভয়ঙ্কর শান্তিময় পলিটি
শান্তিময় পান্ডা
তাই বলে তো
My Guru Melon, Mr. Panda.
How is it?
Yes. Huh? শান্তিদা ল্যান্ডলর্ডে বলতে হবে
Authority. Was an authority. Landlord.
All out player. Let's get
No, not required. If the respondents are not here, keep it with you.
Lordship, unauthorized construction, Lordship, section 10 on concluded. Lordship, this application for implementation of under section 10(3), Lordship.
You are there.
Lordship,
but I am brief কি ম্যাটারটা কি বলো
unauthorized construction, section 10(3) pending release.
Showing the
Lordship,
একটু দেখে না হ্যাঁ তুমি বলো মালিককে বলে
Lordship, kindly see page 39 annex of P6, Lordship. The assistant engineer issued under section 10(2), Lordship, to the SDO for continuation of section 10(3) of the
SDO should complete the proceeding.
Lordship,
Yes,
Lordship, Lordship, page 39, Lordship, annex of P6. More than 1 year lapse, Lordship, still pending.
দাঁড়া আমি একটু দেখি
Where is your affidavit of service?
দাও দিয়ে দাও তোমরা দাও
পুরো হয়ে তো যাচ্ছে হোক না
দাঁড়া আমি একটুখানি দেখি
Affidavit of service filed in court today is taken on record. Mr.
Mobaidul Hussain. Mobaidul Hussain. My lord, Mobaidul Hussain.
Mobailur
Hussain.
This is 20.
Mobailur Hussain, learned advocate, appears for the petitioner. Mr. Soumitra Bandyopadhyay, along with Mr. Priyabrata Bhattacharya, learned State Counsel, appears for the state respondent.
The subdivision officer.
Private respondent is there.
Lordship, have served Lordship.
Yes, my lord.
Private respondents are not represented, despite notice. Referring to Annexure P6 at page 39 to the writ petition, Learned Counsel for the petitioner submits that the jurisdictional assistant engineer, PWD, by its communication dated August 14, 2025, after ascertaining August 14, 2023, কি বললাম? Has referred the matter before the jurisdictional subdivisional officer. After finding the encroachment on PWD land at the behest of the private respondents. So stop. Since then, no step has been taken by the subdivisional officer. Paragraph. In view of the above, after issuing a prior hearing notice to the petitioner, how many? Singular or plural?
Petitioner.
Five
Petitioners and the private respondents the jurisdictional subdivisional officer shall conclude the proceeding in accordance with law. And shall take all necessary and consequential steps in accordance with law, positively within a period of 8 weeks from the date of communication of this order. Full stop. The petitioner shall also serve a copy of today's order upon the private respondents and shall place the proof of service before the subdivisional officer.
My lord, your lordship also, my lord, give direction upon the assistant engineer also to be present before the hearing.
In the event any assistance is required, the subdivisional officer shall take such assistance from the jurisdictional assistant engineer PWD. From the jurisdictional assistant engineer, PWD. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. ওগুলো তো হবে না। With the above observations and directions, this writ petition WPA bold
Number 9104.
9104 of 2024 stands disposed of, without any order as to cost.
Great. Lordship, item number 42, Lordship, I am for the petitioner, Lordship.
42,
Lordship.
I am on now.
For the petitioner,
47
Lordship.
Now, what is the serial number?
47, Lordship.
Huh? 47 হচ্ছে 42 চলে গেছে। Next up.
I'm here. This is my applications.
Take the microphone.
Yes. No, this is the application for early disposal of appeal which is pending, which has filed before the divisional commissioner. Appeal under Rule 51 of the concession rules. Now, for early disposal of my appeal.
Affidavit of service filed in court today is taken on record.
Affidavit of service.
Mr.
Mir Anwar.
Mir
Anwar.
Mir Anwar.
MIR.
That's right, Mir.
Yes.
Mr. Mir Anwar, learned counsel, appears for the petitioner. Mr.
Sanjay
Saha, learned counsel, appears for
Respondent number 5.
respondent number 5.
And Mr. Des.
Mr. Chundi Charan De, learned additional government pleader, appears for respondent number
124.
1224.
124.
The sole grievance of the petitioner is that the appeal, come on, show me the appeal paper.
Appeal paper, Lordship, page 25, the first page of my appeal applications.
কি বললুম?
Page 25.
Preferred by the petitioner under Rule 51 bold করে of the West Bengal Minor Minerals Concession Rules 2016. West W cap, D Bengal B cap, minor M cap, minerals M cap, concession C cap, rules R cap, 2016.
Lordship, it was filed on 22nd June. 2020. This appeal was referred on 22nd June.
কি বললাম?
Appeal preferred by under Rule 51 of
is still pending and not disposed of by the jurisdictional appellate authority. Paragraph. Accordingly, the jurisdictional appellate authority.
So now 2. Respondent number 2.
comma, being the respondent number 2 herein, after granting opportunity of hearing to the parties to the said pending appeal, annexure P6 at page 25 to the writ petition, shall dispose of the same by passing a reasoned order in accordance with law. Full stop. Paragraph. The entire exercise shall be carried out and completed by disposing of the appeal in accordance with law by the respondent number 2 positively within a period of 8 weeks from the date of communication of this order. Full stop. It is made clear that this court has not gone into the merits of the claim of the petitioner in the appeal or in the writ petition, and the jurisdictional appellate authority shall decide the appeal independently without being any observations made by this court, without being influenced by any observation made by this court, full stop, without being influenced by any observation made by this. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. With the above observations and directions, this writ petition WPA 91
9138.
Bold, huh? WPA 9138 of 2024 stands disposed of, comma, without any order as to costs.
Lordship, one indulgence that the appeal application which has been annexed as shown is page 25. This is the first page, just to show the endorsement. Entire appeal has not been annexed.
Doesn't matter.
Lordship.
Appeal is already filed. It
Appeal
is on
filed.
record. How does it matter?
Appeal number. Lordship, kindly mention one this
The appeal number.
Yes.
There.
Asun to
It's not there.
appeal number
Appeal
কত
number
পাবো?
10. Not there.
প্রথম দিকে চলে যান।
appeal number তো পাইনি এখনো।
Sole grievance.
appeal number তখন
Yes,
পাইনি।
appeal number.
appeal number I have not
Not there in the.
ছেড়ে দিন, কিছু করতে হবে না।
immediately ওটা তো স্যার দেয়।
Next.
এই দু সপ্তাহ মধ্যে তো। Oh. Well, this is my application. This is
কি স্টকের কি হয়েছে? স্টকের তো এই অপশন
এটা অনেক ঝামেলা ঝামেলা।
এক অবস্থা। কি বলছে? বলছে সারা হাইকোর্টে সার্ভার ডাউন, কোনো বোর্ড চলছে না। তাহলে লোকে আসবে কি করে?
হতে পারে হতে পারে। এই বলছি
ডাকতে থাকুন, যদি দুপক্ষ থাকে নেব, নাহলে নেব না। তাতে যদি 5টা মামলাও এগোবে।
এটা
Yes.
Yes, this is my applications.
এটা বোধহয় ওই স্টক এক্সেস যে স্যানিটা সিজ
So this is I am for the petitioner hearing.
দিয়েছে।
The affidavit-
Appeal.
This is not appeal. This is the different matters, but the concession rules and West Bengal minor mineral rules.
Any appellate forum is there?
No, Lordship, this is thing
Yes. Proceed.
Lordship, the petitioner was a successful bidder for a stock of the sand stock. Sand stock. And the application was the petitioner was the successful bidder, and bid and the premium of the bid money was deposited. Thereafter, the petitioner was directed to sell the deposit the entire bid amount. But subsequently, the petitioners went to the stock point and found that the entire which the quantity of sand was auction, that sand was not there. So she made an application. They kindly give a measurement of the stock which has been put an auction. But
Disputes with regard to
quantity of sand. But the subsequently it has what happened because the sand was going on lots of theft. So this is the grievance. Lordship kindly come.
How can I do it in the writ court?
Because
Is there any arbitration clause?
No.
This sand that was seized by the adjustment that was put into auction. After verifying the stock, he participated in the deed, submitted the deed amount. Now it is the case of the petitioner that the entire stock is not there.
Entire stock is not there.
Go and file a civil suit.
No, Lordship kindly.
How do I know?
Lordship?
How do I know entire stock is not there?
But the DM authority, ADM is the authority.
No.
That is the Lordship. I have made on several times for applications.
How do I know your client is speaking truth?
Lordship, the inspection has to be carried out.
No. Writ court is not to cause a roving and fishing.
I have paid the entire money.
Yes.
Not paid, 1/3. 1/3 entire paid.
File a civil suit. To file a civil suit.
Lordship, they have already initiated the criminal proceeding.
Against you?
Against me.
Yes, you face the trial.
That I am facing. Now that
Writ court I will not entertain.
Lordship, what I have paid the entire money. Whatever my amounts.
He is the offender. He is purchasing the.
No. What he is doing? What he is doing? Mr. Bandyopadhyay. What he is trying, not he, it's all right. What the petitioner is trying to do. If he gets an order from the writ court, he will immediately place it before the criminal court. That look here.
Not be maintained.
Look here. I was given a clean sheet. I am given a clean sheet by the High Court.
No, Lordship, not that. I have taken a bail from the criminal court. I am on bail.
Sir, bail is an interim arrangement.
Trial face.
I face trial. It is not that. But the problem is that I have paid the money for the amounts.
You go for recovery. You go for a recovery proceeding of the money. There, if you have any further claim, you claim. How the writ court will do?
If you even my application which has been made several times that has not been entertained, let them decide.
Case, sir, you don't have any case in a writ court. Ashun.
Lordship, just a moment. Kindly see my last representation, which has page 30.
Doesn't matter to me. Because how do I ascertain the fact? How do I ascertain? You are saying that 10 kg was put for auction. You have paid money according to 10 kg. Subsequently, you discovered it was 5 kg, not 10 kg. So what will happen to you? How do I know? Sitting in a writ court?
This is the authority, is the government authorities.
So what? Ashun. Excess sand block was for a particular quantity was put for auction by the state authority. Petitioner participated in the auction process for such fixed quantity of sand block and deposited
about 9,61,000.
A sum of about more than 9 lakhs.
Total. 1/3. My prayer is the
deposited a sum more than 9 lakhs on account of premium.
1/3 premium.
To participate in the auction process. Subsequently, the petitioner discovered that the fixed quantity which was put for auction, fixed quantity of sand block which was put for auction was not the actual quantity on the basis whereof the petitioner has paid the amount, but is a lesser quantity. Paragraph. Petitioner has submitted representation before the state authority but the same has not been considered.
Lordship, one intelligence is that what I have paid that amount, for that amount that is the issue challan may be issued. This is the first prayer. Lordship, kindly come the first prayer.
That cannot be.
How can I do?
That cannot be.
You have proceeded, you have participated in an auction for 20 kgs. You have deposited 1/3, 6 lakhs. Right?
Right.
You found it is not 20 kg, it is 10 kg. Now you are saying that for 6 lakhs equivalent quantity you give it to me.
No, not that. I have just paid the amount 1/3 of the bid amount.
That's right.
And that quantity of 1/3 sand is there.
Who will go and inspect that? Who will measure that? Sitting in a writ court.
MDT says the respondent of 5.
You file a
Lordship,
civil suit.
issue a challan. That the
Not been considered. Very well. The petitioner now claims before this court that the proportionate quantity of sand block can be released in favor of the petitioner,
by issuing challan,
which would be equivalent to the sum of rupees more than 9 lakhs.
9,61,000.
9,61,000.
371.
371. কি বললাম?
More than 9 lakh, you also বলেছেন।
Now, then, before this court, which would be equivalent to the sum of rupees
More than টা হবে না? Which will be equivalent to rupees 9,60,000 deposited by the petitioner. Paragraph. Mr. Soumitra Bandyopadhyay, Land and State Council, appearing for the state respondents, submits that. Yes, sir. What is your submission?
Well, it should not be. He is the offender, my lord. He
submits that the state authority has already initiated a criminal proceeding before the jurisdictional criminal court against the petitioner, and the trial is pending. Full stop. The petitioner has been found allegedly to be guilty by the state authority, for which the criminal proceeding has been initiated, and the petitioner has been enlarged on bail. Paragraph. After considering the rival contentions of the parties, sir, what do you say, Mr. Sanjay Shah, Land Council, appearing for respondent number, submits, 5 submits.
It is for the additional district manager who has put the certain quantity of sand into auction. If ultimately in the criminal proceeding it is found that the petitioner is not guilty or guilty, subject to outcome of the criminal proceeding, the ADM will recommend.
That the respondent number 5, is the appropriate authority for holding. Now 5 now.
No, we are not. The additional district magistrate.
And the respondent number 3.
ADM is 3.
Is the appropriate authority to hold and finalize the auction.
Yes.
Full stop. If others submits that considering the nature of the criminal case pending against the petitioner, the fate of the auction process shall depend upon its final result. Paragraph. After considering the rival contentions of the parties and upon perusal of the materials on record, it appears to this court that there are a lot of disputed questions of facts which cannot be adjudicated by this writ court. More so, the criminal trial is pending against the petitioner. on the alleged charges concerning with the same tender process. If ultimately the petitioner is acquitted in the criminal trial, then only his fate under the tender process shall be decided in accordance with law. Paragraph. However, if the respondent number 3 at its discretion thinks it fit that the proportionate quantity of sand block can be made over and delivered to the petitioner equivalent to the sum of rupees 9,61,000
371.
371.
Lordship, proportion sand block, no sand.
Sand, okay, sand. কি বললাম?
Proportion stock sand.
Quantity of sand can be made over and delivered. Some of it is
Masked.
Which has been deposited by the petitioner, comma, the respondent number 3 shall be free to do so
Grateful.
in accordance with law. But such observation of this court shall not have any mandate on the respondent number 3. Full stop. The respondent number 3 shall exercise his discretion in accordance with law, and if he thinks it fit, then only he may proceed to deliver the proportionate sand to the petitioner. Paragraph. If the petitioner ultimately chooses and decides to recover its amount paid by him, comma, the petitioner shall be at liberty to initiate appropriate civil action for recovery of its deposit from the state authority before the jurisdictional civil court in accordance with law. Full stop. Paragraph. It is made clear that this court has not made any observation with regard to the merits of the criminal charges, alleged criminal charges leveled against the petitioner by the state authority on which the criminal trial is pending. Neither this court has gone into the merits of the claim of the petitioner in any manner. Full stop. The jurisdictional criminal court shall be free to proceed with the criminal trial without being influenced by any observation made by this court. Full stop. Similarly, if any civil action is initiated by the petitioner, the jurisdictional civil court shall be free to proceed in accordance with law without being influenced by any observation made by this court. Full stop. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition, bold WPA 9426 of 2024 stands disposed of, comma, without any order as to cost. More than this, I cannot help you.
Lordship, grateful.
He has, whatever his prayer was, that he has, your Lordship has granted.
Lordship, great.
In commercial transactions, some liberal attitude has to be there.
Lordship, great.
Otherwise, how the commercial activity will be carried out?
My lord, I am for the petitioners.
Yes.
I appear for respondent numbers 15 and 16.
No, repetition is not maintainable.
Not maintainable, my lord.
Yes, what is the petition, sir?
My lord, the land joint owners.
Take the microphone.
The petitioners.
See the prayer.
Writ petition.
The petitioners are
Take your seat. Take your seat.
Petitioners are the owners, joint owners of the land, measuring 3.64 acres. Out of that, some of the respondents, they sold their respective shares 1.83 acres with the connivance of the statutory respondents. Because
statutory respondents mean?
My lord, the the registering authority and BLRO, block land revenue officers. Because, my lord.
How can you maintain prayer A in a writ court?
My lord, I am coming, my lord. Kindly allow me to submit.
But show me, I accept fraud. I accept mischievous connivance. Show me that you are entitled to maintain prayer A.
My lord.
I admit your case on facts. Serious fraud. Maintain your writ petition on prayer A.
Yes. My lord, in this connection, I beg to refer Honorable Supreme Court's judgment in a particular case, Asset Reconstruction Company Limited versus SP, Velayamatham and others.
Under Suffici Act.
No, my lord. This is like this only. That registering authority, they have fraudulently registered this land, that property. This one I beg to refer, my lord.
তোমার রিটটা দেখা, রিটের পেয়ারটা দেখা, রিটের পেয়ার দেখানো, ফ্রন্ট করেছে, চিট করে কেন, চিট ক্যান্সেলেশন কি করে, চিট কোড কেন প্রথম লাইনটা কি?
Yes. What is your case?
My lord, due to the registering authorities' inaction, I have been prejudiced. My land already it is converted in such a way without conversion, without intimation to me. It is converted. Now it is dug up. My lord, lordship will kindly allow me to show the photograph what I have taken.
Photograph. What is the case made out in the writ petition? What is your case?
Case is that
you have a property. You had a property.
My lord.
Then how this property was transferred?
There was a total 3.64 acre land in a particular plot. Now, our share, my petitioner's share is 1.1433 acres. And the respondents, private respondents, they have sold out 1.83 acres.
Who is for the private respondents?
I apply for 15 and 16 the purchase.
All right.
That it is sold out. Now, as soon as it is sold out, it is totally agricultural land. And in those areas, it is single areas. There are twice, thrice, the yield is twice, thrice. Now, after Tadpur block, Bedabadi, these areas are totally in the single vicinity, that single revolution.
Singur block alada, Pulva Tadpur block alada.
No, doesn't
What I
matter.
am
Doesn't
telling-
matter. Doesn't
what I am
matter. We
telling
are
is
hearing on a
area.
point of law.
Learned
Doesn't matter, Mr.
Learning.
Bandyopadhyay. We are hearing on point of law. Yes.
Oh, very well. My lord, that is, yield is twice or thrice. Now, after this is sold off, the part is sold off. Now, my portion means actually like by Solanama, among our all relatives, this is ancestral property. We have just adjusted like that. You take this 0.23 acres like
How
that.
you maintain prayer A
My
in
lord,
view of this judgment?
in view of the judgment is that the registering authority blatantly that they have done wrongly. And
what wrong? What are the violation of the
my
provisions of
lord,
registration
yes, my
act?
lord. Section 21 of the registering the act. ওদিকটা আছে 21 ওইদিকে হ্যাঁ।
Yes. Read on.
That copy that is not with me and that copy. Actually, my lord, that section 21 is violated because as per section
Read on. Read on.
My lord, I have not another book. Sorry.
Then what to do? How do I read?
Kindly, my lord, kindly allow me to next hearing.
Yes, section 21.
My lord.
Yes, read on.
My lord. Description of property and maps or plans. No non-testamentary document relating to immovable property shall be accepted for registration unless it contains a description of such property sufficient to identify the same. Houses and in towns shall be described as situate on the north or other side of the street or road, which should be specified to which they front and by their existing and former occupancies, and by their numbers if the houses in such street or road are numbered. Number 3, other houses and lands shall be described by their name, if any, and as being in the territorial division in which they are situate, and by their superficial contents, the roads and other properties on which they abut, and their existing occupancies, and also whenever it is practicable by reference to a government map or survey. No non-testamentary document containing a map or plan of any property comprised therein shall be accepted for registration unless it is accompanied by a true copy of the map or plan, or in case such property is situate in several districts, by such number of true copies of the map or plan as are equal to the number of such districts. My lord, that it is just joint property and particular plot. My lord, can you kindly allow me to show the photograph? It will be more clear, I think.
Sir, photograph, what do I do?
No, my
I
lord.
will have to go by the document.
Yes, my lord, that is there, my lord.
Photograph, how do I know it is a
Humble-
photograph of
humble
Darkoldanga or
prayer, my
Singhu?
No, my humble prayer, my lord, before your lordship, just to see that my portion and how it is
Not
conditioned.
required. You show me from your
Yes,
petition.
my lord, I am telling. Whenever these dalils, these deeds are written, they are particularly written like this. This north, this portion, this part, this portion, this gentleman is acquiring this north part, south part is this, east part is this, like that way, so that the land can be easily identified. Yes, this portion I have purchased. But if it is just total a plot of land, 1 acre or something like that, out of that I have the share point 3 decimal. If I sell it 3 decimal, it is my property, I have sold. But which part I will take, that would not be clear, my lord. That is the difficulties in landed properties. So if it is not specifically written that in the northern side, Mr. X's property, in the southern sides, Y's property, northeastern part is Mr. Z's properties, like that, so that it is identifiable. Because in the rural areas, the first land, so over there, it cannot be identified by number or something like that. Maybe a particular plot number 283. In plot number 283, there may be 3 acres of land. Now, out of that, X has 1 acre, Y has 30 decimal, like that. So, this one, whenever joint property, then permission should be taken, and they should also sign in the deed. This is generally happened, my lord, in all practical purposes, because I belong to rural areas. I know very well all those things, my lord. This is kindly give me indulgence. So in that case, my lord, here it was not clear. So what happened, whenever the private respondents purchase, they at their sweet will, they have dug off the land. And by that way, my portion is totally blocked. And now this Kharif season, I have lost the crop. Now in the Rabi season is coming, but there also I cannot cultivate because there is water logging and sand is dumped over there and everything. So that's why, my lord, I was trying to show your lordship that photograph what I am losing now. And I have, we are the 2 petitioners, and we have our these laborers. They generally cultivate the land and give me the proceeds and all those things. They are also now suffering, because there's high yielding those areas. Their cultivation is very nice over all those Hooghly district, and one crop is totally lost, and another is going to be lost. And another, my lord, I am telling.
You give a copy of the judgment to all
I
of
have
them.
given one copy, and another copy I'll also give. Just going outside, another copy I can
Give to Mr. Bandyopadhyay.
Yes, my
Let
lord.
them come on the next day after considering this.
And conversion also, my lord, I have one challenge about conversion of the land. During conversion, the permission should be needed from the joint owners. And land reform authority, they are so much nowadays sensitized that even one.
What are the statutory breach committed by the registering authority?
That is, my lord, that section 21. And another also, my lord, that is the registration. Registration was done in the private house, private respondent's house. And that is also not mentioning the reason, because, my lord, in section 31, registration or acceptance of deposit at private residence, that can be done by the registering authority because he has that authority. to open an office over there. But there, my lord, there should be the reason should be mentioned in the registering deed, that for such and such a reason the person is enabled or something like that. But nothing is there. That is totally hush up. Totally, it is hush up. And another point, my lord, that price of the property is 1 crore something.
Come on the next day. Come on the next day.
My lord.
You have to consider the judgment seriously.
Yes, ma'am. Although a cursory glance reveals that may not be factually applicable in our case, but we'll consider it at length and come back to that.
The judgment says very serious thing. Judgment says what had happened. Writ petition was filed.
রেজিস্ট্রেশন অফিসে কপি দিয়েছেন রেজিস্ট্রেশন অফিসে কপি জমা দিয়েছেন
সবাইকে দিয়েছি 18 জনকে দিয়েছি
না রেজিস্ট্রেশন অফিসে কোনো তাহলে ইনস্ট্রাকশনটা নিয়ে নিন
Mr. Bandyopadhyay, you must come prepared on this judgment.
I don't know whether the copy has been served upon the register office or not. Whether they have received or
You are receiving, you are appearing for the state.
then I have to take
You take instruction.
But it is the duty of the when they have made respondent.
Mr. Bandyopadhyay, you are appearing for the state. You take instruction.
I shall take
come back.
instruction.
My lord, I have
Very
given
question.
district registrar, deputy inspector general or registrar, and everybody I have given.
I shall take instruction.
If you do not take instruction, then I will have to
No,
call
I
for
shall
them.
take instruction. My must.
And the judgment is very important judgment. What had happened? First, a writ petition was filed. On the same ground, the writ petition was dismissed. That it's a civil dispute, go and file a civil suit for declaration. Sorry.
Writ petition was allowed.
Petition was
Division
allowed.
bench set aside.
Writ petition was allowed.
Yes.
Writ petition was allowed, holding that the Registration Act provides for certain statutory obligation on the part of registering authority. In the facts of this case, registering authority has failed to perform their obligation. Therefore, writ is maintainable. Consequentially, if the deed is to be upset, it has to be upset.
Yes.
Division bench negated that observation and dismissed the writ petition that no, this is a fit case for civil court. Traveled up to the Honorable Apex Court. The Apex Court held the same thing as the single bench allowed the writ petition. The Apex Court said, look here, these are the entire analysis and discussion on the Registration Act, and said, these are the obligations which are minutely to be followed by the registering authority. If a registering authority, which is an Article 12 authority, commits a breach of its obligation, 226 is maintainable.
Yes, Manoj, that is. The only thing is that in this case, this judgment, it was a question whether the power of attorney given to the agent was registered or unregistered.
No.
It was unregistered.
No. There the case was whether the registering authority at the time of registration of the deed examined the power of attorney or not, and the natural person or not.
Yes, Manoj.
Which is the duty cast upon the registering authority. If he fails, 226 maintainable.
Yes, Manoj. That is what is. That is what is.
That's Supreme Court. It is not on declaration of title or not on.
No, not on that.
The cancellation of deed.
No.
Cancellation of deed in this case was eventual.
Consequential.
Consequential.
Yes. We shall come back.
Copy
But will it be a Lordship's pleasure to grant us some time to file an affidavit because allegations? Because, my lord, I'll tell you, Lordship, allegations have.
To argue on the maintainability.
On the law, we shall argue, and thereafter, if there is any disputed question of fact, we shall file an affidavit.
First, you maintain
on the ground of maintainability. Very good.
If the writ petition shows, right. Before whom it was registered?
DSR 1, Hooghly.
Respondent number.
My lord.
Additional respondent number 3.
DSR 1.
Considering the cause in the writ petition,
কোথায় দিয়ে স্যার?
and considering the reliefs claimed therein,
Respondent number 7.
So number 7.
the respondents raised the point of maintainability of the writ petition. Full stop. The respondents jointly submit that for declaration for annulment of a registered deed of transfer, no writ petition is maintainable, and it is only the civil court which has to take cognizance, because several fact-finding inquiry are required to be made. Paragraph. On the issue of maintainability, Mr.
Nilkamal Ghosh.
Nilkamal Ghosh, learned advocate appearing for the petitioner, learned counsel appearing for the petitioner, submits that in the identical fact situation, the Honorable Supreme Court held that writ petition is maintainable, and in support, he has relied upon a decision of the Honorable Supreme Court dated May 4, 2022, rendered May 4, 2022 in the matter of the asset reconstruction versus SB Venapullam, in the matter of, to search out whether it is reported. It's reported, I think it's reported.
It should be.
Because it is a reportable judgment.
Yes, should be reported.
Very well versed judgment. So it must be.
May I search out now? Your Lordship.
Then you bring that SCC printout.
Yes.
Right?
Yes,
Bring
my
that
dasher.
SCC printout for me also. Because it has let down the laws. It must be reported. Rendered in civil appeal numbers, such and such, such and such. Learned counsel for the respondents pray for some time to deal with to consider the said judgment.
It is reported.
Come back. Yes, reported.
Yes, 2022 volume 8 SCC
2022
volume 8 SCC 210.
2022 volume 8 SCC
210.
ঠিক আছে, লিখে রাখুন reported at, লিখে রাখুন rendered in such and such, reported at 2022 volume 8 SCC 210. You bring a SCC online copy for me also. কি বললো? Full stop. There is no scope for any interim order. Who is the registering authority who registered?
DSR 2, that is
respondent number.
7.
You give all your appearances by mentioning the respondent numbers. Full stop. Since the allegation has been principally made against respondent number 7, who has registered,
My lord.
This said the subject transfer date, comma, the respondent number 7 shall file an affidavit in opposition for the time being, dealing with the allegations made in the writ petition. Full stop. Such affidavit in opposition shall be filed on or before November 20.
Well, it should not be, my lord. Some more time, my lord.
November 20.
My lord, there are some holidays in the government of West Bengal.
Huh?
In this month, 14 now holidays declared by the state of West Bengal.
November 27, 2024. Affidavit in reply, if any, thereto, shall be filed by December 5, 2025. 4. The writ petition shall appear under the heading for orders on December 10, 2024.
But may I also file an affidavit only restricted to the allegation that
Very well, সবাই ফাইল করুক, হ্যাঁ একদম করে টেনে দাও। কি বললাম? শেষ করবো ওই দিন যা হবে। কি বললাম? কিছু বলার দরকার নেই। কি বললাম? Since there is no
Affidavit by affidavit.
full stop. File an affidavit in opposition. Paragraph. The other respondents shall also file their affidavits in opposition. Such affidavits in opposition shall be filed বলে on or before যেটা বলেছি 27 November. The affidavit in reply shall be filed by the writ petition shall appear under the heading for orders on December 10, 2024.
Great.
লিখে দিন তো ওটা একটা সাদা ফাইল করে, যেমন আমার গাঁথা থাকে সাদা, ওইটা না জাজমেন্টটা করে ওর মধ্যে ঢুকিয়ে দিন।
I am for the petitioner in this matter. My lord, I prefer the private respondent, my lord. My lord, in this matter, there is an allegation, my lord. There is the allegation with regard to encouragement of the PWD Act. My lord, on the landed property, earlier I noted a petition, and your lordship has passed this order, but not the same petition. Our separate my lord plot owner, he lodged a complaint, and my lord also directed my lord to decide the issue by the my lord PWD. My lord, this separate plot owner, my lord, he has also lodged a complaint, and this is my lord, I filed a writ petition. My complaint at my lord page 70 of the writ petition.
Similar matter, order was passed.
Yes.
Now you are a different set of petitioners, you are praying for the same orders.
That's the reason I was saying that the writ petition is not maintainable, because of the reason that your lordship has already passed an order directing inquiry and giving opportunity of hearing to the
Same
parties.
order will be passed.
He was also a party to that, and he was also privy to that, and he was also been called on, inquiry was done. He was also separate petitioner. But he was also present in the inquiry. He was also been called. But petition was separate. My lord, the earlier petition was filed by Niranjan Mati.
Not going into the technicalities. My lord, I have got the report. My lord, report says the allegation made by the petitioner is not correct. Because adjacent, this is not, his plot is not the adjacent plot of the PWD road. In between there is another plot, Rayati plot. Hence, this provision cannot be invoked.
And my allegation was that.
Wait. The report you have brought is in respect of that writ petition.
No, in respect of this writ petition.
This writ petition?
Yes.
Who filed this report?
Well,
PLLRO?
Executive Engineer, Tomluk Highway Division. And they were put on notice. Inquiry was held.
Watch, in this writ petition,
Yes.
already inventory has been done.
Yes.
Inspection made.
Yes, my lord, kindly come to my lord, second page.
This is your report.
Yeah, this is the one.
All this has been done in compliance of your lordship's earlier order.
So earlier writ petition has lost its force.
Yes.
Because in view of this report,
No,
there
that is still, the cause of action is still pending. Inquiry is done, hearing has not been given, a further inquiry has been given. So your lordship's order is still in session and in
no.
force.
So I directed first stage inquiry to be made by whom?
By my lord, your lordship would
BLRO.
Yes, my lord, respondent of 5 BLR.
BLRO. So where is that BLRO report?
Now, my lord, kindly come to
Page
page
state can lord.
page 4. That is the Bureau report. And
in compliance of my direction.
yes, my lord, these
One
proceedings.
second. Don't get so excited.
My lord,
Slowly.
kindly come to page 4.
1 second. Yes, slowly.
Subject. My lord,
Submission of field
measurement report.
Analogous
Connection.
WPA
Yes.
and WPA in the matter of etho and etho.
That is the previous one, WPA 11887 of 2024. My lord, did pass the order on 8th August. So two writ petitions numbers are there.
Including this.
Now, my lord, BLLRO is relying on the report of the revenue inspector that is in the next page. My lord, kindly come to page 5.
BLRO, he himself had not physically inspected.
No.
Give me the order.
All right. My lord, for that I need to see. Are baba, okhane
Give me the order, previous order.
Second page, my lord. Second.
No, ওটা আমায় দিয়ে দিন।
No, five shall refer the matter with this file আটকে ছিল ব্যাপার।
সেই রিটে আমি তো জানি না। ওই রিটটা আছে লক্ষ্মী?
এই রিটে আরেকদিন আমি ক্লিয়ার করেছিলাম।
Who was respondent number 5 there?
BLR.
Show me that BLRO has caused the physical inspection.
In that lot, the respondent number 5 was the executive engineer, PWD directorate. 6 was the block land and land defense officer. Your lordship, lord, directed lord, the respondent.
I directed respondent number 5.
Lord, yes.
5
to refer the matter before the respondent number 4.
No, considering the rival contention of the parties on perusal materials on record, respondent number 5 is directed upon prior notice to the petitioner and the private respondent to cause a physical inspection. Who was respondent number 5?
Executive engineer. I can see executive engineer.
Was the respondent number 5?
Yes.
Earlier
petition. The earlier
ওর কাছে আছে আমার কাছে
the copy of the petition.
দেখি দে।
Give me.
The lordship would kindly to my lord.
Yes, executive engineer, PWD. So he caused the inspection.
They were also notified, they were also present.
Fair enough. He caused the inspection and he came to a finding.
Yes. Kindly come to page 2. Page 2.
Can say. Mr. Dhar can say.
As per available office record, there is no other documents which confirm that the piece of land being RS plot number such and such corresponding LR plot number such and such is kindly ignore that, belong to PWD Roads Directorate. Moreover, there is a Rayati land being plot number 650 JL number such and such in between government plot number 1 of Mouja Moishali JL number such and such and petitioner plot number 649 JL number such and such Mouja Naikuri Jogotnokchok. Hence, the petitioner's plot in question is not just adjacent to Pashkura Durgachok Road, and no question arises regarding obstruction for direct ingress.
Where does it say that there is no encroachment?
Yes. And deeply objection. That is pending. It is not concluded yet. That means that proceedings is pending. It is not concluded yet.
Now, kindly come to the page 5.
Yes. 11879 is this writ petition.
11887 is the earlier writ petition.
Earlier.
887.
Yes.
And 889, 879 is this one.
This one.
So this one is also taken care of.
Yes. Well, kindly come to page 5.
So let the final report come. I have disposed of the writ petition.
Yes, that's the reason I said that this writ petition is not maintained.
All right.
Because he has already
So,
participated.
so previous writ petition, I cannot reopen anything.
No, nothing.
On the basis of this report, what will happen by the SDO.
By the SDO.
What will happen. If no encroachment, nothing will happen. If encroachment, remove it. Whatever will happen. Now, in this writ petition, what do you say?
This is the separate writ petition.
Ah.
My file was the separate writ petition.
Correct.
He has also alleged with regard to the
But your writ petition has been considered. Your writ petition plot
that was
is considered.
before he has made an inquiry. The proceeding was initiated as per section 10 of the West Bengal Highways Act. There is no such proceeding was initiated. Only the inquiry was done. Let the proceeding be initiated. I have a right of audience, my lord.
All right. Let me do one thing.
That has been initiated.
That is with regard.
Initiated in respect of previous writ petition.
Already the proceedings is
I
initiated.
will simply say, in respect of this writ petition, both those two proceedings should be heard analogously. Not an inch.
But I said, Lord, already the cause of action has already been taken care of. Your lordship has passed on order. This
Very well.
subsequent blood.
But it has to be disposed of.
Yes, he has been heard. He was there in the inquiry.
I will record that.
Your lordship would kindly record that and let it be heard to.
He is participating before SDO. SDO.
My lord, I am participating on the basis of not earlier proceeding. But on the basis of a proceeding, a notice was served upon me.
So on the basis of this writ petition, you are also participating.
Let the proceeding, but my lord, there is no formal proceeding was initiated. On the basis of my complaint, my lord, they have been called for.
Right.
Let the proceeding be initiated.
Why?
Section 10 was not even initiated till date, my lord.
If it is found that no encroachment, why?
My lord, if upon initiation of the proceeding, it is found that my proceeding may be dropped. But my lord, the proceeding should be initiated, my lord.
Ashud. Plot is the self-same plot.
Self. It is the plot of the private respondent.
No, my lord, this is the government plot. Government Khotiyar number 1.
Previous writ petition plot and this writ petition plot is the same.
His cause of action in this writ petition that he has filed a representation before the authority. Authority has done nothing. Whereas my report says that authority has already taken up his cause and authority has inquired.
Petitioner complaint, affidavit of service filed in court is taken on record. Mr.
Lokinath Bhattacharya.
Lokinath Bhattacharya, landed advocate, appears for the petitioner. Paragraph, Mr. Sabir Ahmed, landed counsel, appears for private respondent numbers
8 and 8, 9, 10.
8 to 10. Paragraph, Mr. Supratim Dor, landed state counsel, appears for respondent numbers.
Respondent number.
State respondent.
1 to 5.
One.
No, my lord, 6. 6,
One.
my lord, sorry, 7. Till 7. 1 to 7.
1 to 7. Paragraph. The self-same plot against which encroachment has been alleged by the petitioner on the PWD land was also the subject matter in WPA 11887 of 2024, though the petitioners were different. The said previous writ petition 11887 of 2024 has already been disposed of by this court by an order dated August 8, 2024. Paragraph. Pursuant to the direction made by this court on August 8, 2024, who inquired? Assistant engineer.
Yes, executive engineer.
The jurisdictional executive engineer.
Physical inspection was done by the BLR. Report was filed by the BLO to the assistant engineer referred the matter to the executive engineer. No, that is the report says.
আচ্ছা কি বললাম? The jurisdictional block land and land revenue officer has made a physical inspection of the alleged encroachment. Full stop. Today, Land State Council has filed a bunch of papers containing the reports of the jurisdictional executive engineer PWD dated June 20, 2024, comma, the report of the BL and LRO dated June 20, 2024, the report of the assistant engineer Tomluk Highway Division dated May 10, 2024, inter alia, and the report of the revenue inspector dated June 20, 2024. Made over this কি বললাম বলুন তো? তিনটে হলো, comma, the same are taken on record along with the site map. Full stop. Now, along with the record of right, copy of the record of right and the site map, comma, the same are taken on record. Copy of the said bunch of document has also been made over to Mr. Lokshinath Bhattacharya, learned advocate appearing for the petitioner. Paragraph.
As also, my lord, to Mr. Ahmed.
And also to Mr. Sabir Ahmed, learned advocate,
I want to
appearing for the private
give an exception
respondent.
to the report, my lord, because exception, because my lord, there is no finding with regard to, my lord,
Paragraph.
encroachment of the government.
Paragraph. After considering the said reports, it appears that the BLRO, BL and LRO has also caused the necessary inspection in connection with the self-same plot. Of the self-same plot, in connection with the instant writ petition being WPA 11879 of 2024 also. Full stop. The reports show that there has been no obstruction on the egress and ingress of the petitioner's land, on the egress and ingress of the petitioner to its land. Full stop. However, the reference is now pending before the jurisdictional subdivisional officer. Full stop. In view of the above, the jurisdictional subdivisional officer is also directed to take cognizance of the instant writ, to take cognizance of the case made out in the instant writ petition, that is WPA 11879 of 2024 also. Full stop. The petitioner in the instant writ petition shall also be served with a prior notice of hearing so that he can also participate therein. Full stop. This court is informed by Mr. Sabir Ahmed, learned counsel for the private respondents, that this petitioner has already been participating in the proceeding before the jurisdictional subdivisional officer.
That is executive engineer. The Lordship has directed the executive engineer, respondent number 5.
আচ্ছা, so সাবডিভিশনাল অফিসারটা কেটে দিন, ওখানে কি বললাম পড়ুন, তার আগেরটা পড়ুন। তার আগেরটা পড়ুন। সাবডিভিশনাল অফিসার হবে না, জুরিসডিকশনাল
Executive
এক্সিকিউটিভ ইঞ্জিনিয়ার কমা পিডব্লিউডি। পড়ুন পড়ুন, একটু আগের থেকে পড়ুন।
এই প্লটটা ওরা দেখায়নি, সেটা আমি আগের দিন জজকে বলেছি, আমার সাবমিশনের রেকর্ড আছে এটা।
এই প্লটটাকে কোথায় রেখেছে দেখেছিস? এ দেখ, ওর ম্যাপে দেখ, এখানে থেকে
সো দ্যাট
পেছনে নিয়ে এসেছে।
can participate in the hearing. Has also been participating proceeding before the jurisdictional executive engineer
division.
Before the jurisdictional executive engineer PWD. Full stop.
The matter is pending before the sub-divisional magistrate. Matter is not, the matter is still pending before the sub-divisional magistrate. I was been called for by the executive engineer, PW higher subdivision.
They will come to a finding, thereafter they will refer it for the purpose of taking out proceedings under section 10. There has to be blood a primary finding. Then blood the section 10 will come.
No, but there in that order I have directed subdivisional officer.
But your lordship has directed blood respondent number 5.
To respondent number 5. Which is
no. It is made clear that in the event the reasoned order confirms the encroachment and unauthorized construction on the public land, then the respondent number 5 shall refer the matter before the respondent number 4. Who is respondent number 4?
Respondent 4 is subdivisional officer.
ঠিক আছে।
That stage has not yet arrived.
ঠিক আছে। In the event the jurisdictional executive engineer PWD is also of the opinion that there is an encroachment on the subject land, then reference shall also be made before the jurisdictional subdivisional officer
in accordance with law.
Who shall take all necessary and consequential steps to give an immediate effect to the decision of the jurisdictional executive engineer PWD along with the dispute, along with the reference to be placed before him in connection with WPA 11887 of 2024. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition WPA 11879 of 2024, bold, WPA, bold, stands disposed of, full stop. It is, এর আগে একটা paragraph দিন, it is needless to mention that while deciding the issue in this writ petition, the jurisdictional subdivisional officer shall also refer to the order dated August 8, 2024, passed in WPA 11887 of 2024.
The lordship has again said subdivisional officer. That
I consciously said. Consciously said, final stage.
Earlier stage has not come yet because the inquiry has.
Yes, while I said. Consciously I said.
After the reference is made, then
That's
in accordance
right.
with law.
If reference is referable,
then the
if
consequence
encroachment is found, then if no encroachment, why the reference?
applies. Court says there is no encroachment.
No, Report says that there is no obstruction.
Next.
But I'm appearing your petitioner. Lordship permits we put in the affidavit also.
Yes.
Affidavit.
Who is on the other side? Yes.
But this relates to a land or land with structures. Considering
Unauthorized encroachment.
no. So encroachment made much earlier in 1947.
Take the microphone, sir.
It is the encroachment has come up sometime in the year 1947. Squatters colony. This is because squatters colony. And in terms of the squatters colony situation, the predecessor and interests of the present petitioner, she was given a regularization notice or a letter that the property with you is regularized. But I must give a background of this.
I have already passed an order on the squatters colony. Maybe Mr. Oyon Banerjee, Lana State Council, was there. Yes, you proceed.
No, thereafter, two notifications have been made by the government. Those notifications need to be placed before your lordship. One is available at page 912, which is at page 19, page 19. That is notification number 1240, 1240 within bracket 17, rehabilitation, stroke 18R-9/87. This is in respect of the properties which are under the squatters. Lordship kindly comes to page 20. Clause number 2, my lord.
Yes.
Clause number 2, in terms of the existing government policy, freehold right over the title deed may be executed only in favor of the displaced person from erstwhile East Pakistan, now Bangladesh, who is in effective possession of an urban plot or a part thereof with a structure on a portion of it as his own as allotee or Arpan Patra holder, regularized quarters on lands belonging to the state government in the RR and R department, acquired or received through the transfer through the process of law, provided that the said plot is free from legal proceedings, lawsuits, or of disputes in nature. If an allotee or Arpan Patra holder regularized squatter for reasons of age, infirmity, and like desires in writing to have the deed executed in favor of other eligible persons in effective possession of the plot in question, the title deed may also be executed. What I intend to submit before your lordship is the point which is raised is effective possession. Now, my clients admitted, I will put it this way, admittedly are in effective possession in respect of the plot of land. Where there is a structure, there is a two-storied building. They are in possession of that property. Originally 5 katas and all.
What do you mean by effective possession?
Effective, but they are in actual possession of the property.
Uninterrupted actual possession.
Uninterrupted. This is not an adverse possession that way. It's a possession which gives a right or a title to the person. Now, I respectfully submit.
It's a right given under a state policy.
Yes, madam. Now, here, after this, if you come to clause number 4, in case where the allotee or Arpan Patra holder regularized squatter is found dead, freehold right and deed should be executed in favor of the person or persons exercising effective possession, provided that such persons belong to the members of the deceased allotee and swear an affidavit beforehand declaring inter alia that they are the only persons in effective possession or along with some other eligible persons to be named. If the declarations in the affidavit in such cases are subsequently found to be materially untrue, the deed shall be cancelled. Then 5, where the lease deed has been executed and lease.
Now, what is your case now?
My case is very small.
Have you received any threat for termination or eviction?
We want a freehold title deed. We are the
leaseholders, sorry, the effective possession holder in respect of the property under one, Jyoti ki Rai Chaudhary? Reba Rai Chaudhary. My name, Reba Rai Chaudhary. Yes, Reba Rai Chaudhary.
What's the original LOT?
Original LOT was one Joy Lakshmi Roy and another person.
No. Joy Lakshmi Roy was the, let's say, Joy Lakshmi was the original LOT.
Yes.
Now, how do you claim your right?
Joy Lakshmi Roy happened to be my mother's mother, that is my grandmother.
Grandmother. So, you are claiming, let's say, as a legal heir.
Yes, as a legal heir.
As a legal heir.
Absolutely as a legal heir.
Now, does this policy confer any right of ownership?
Yes, that is why we want freehold title deed.
Yes. So I'm asking that. Show me that it will give you a right to have a freehold land.
Yes, I'm just showing it.
Take your seat, sir. Then the next question come under what circumstance?
Yes, yes, definitely I'll show it. Now it comes to page 22. This is
22.
Annexure P2.
Yes.
This is given to the Refugee Rehabilitation Commissioner of West Bengal, amendment of Government Order number 1240, which I was just reading, dated such and such for conferment of right and title to the refugee settlers in West Bengal. Lordship has got it?
My lord, in those matters, my lord, that is, if he filed an application, my lord, then we can consider that as because
We have already filed an application, already hearing has been done, but no order has been passed on 22.
So, all right. Where is this application? Show me.
My lord, that is the appropriate.
My lord, kindly see.
He has the right, my lord, according to the. We have given so many.
Show me the application, Mr. Mukherjee.
My lord, first let me show the notice which they have given. My lord,
Not required. You show me the application.
That is the procedure. Only for that reason I have.
application দেওয়া আছে কথা বলো application দেওয়া আছে দেখাও আমি যেটা করতে থেকে পাবো
Page 50. Page 50.
Just a minute, my lord. Yes, my lord. I'm grateful to your lordship. Page
29 January.
29 January 2019.
It's the application.
This is the application.
Page 50.
My lord.
And you say that you have participated in the hearing.
Yes, yes. They have called us for hearing. It is here, my lord.
Give me that notice.
In page 25.
1 minute.
My lord comes to page 25.
25.
This is a speed post notice dated 20th of June 2022.
You are sure that you have participated in the hearing?
Yes, yes, we have.
You have?
Yes.
So I will simply direct, recording these facts, I will direct them to communicate the reasoned order?
Yes, that is what.
Within time?
Yes. There is no reason. I think my friend will also agree. There is no reason to otherwise deny us the right.
No. He has suggested. It is he who has suggested right now.
That will cover up
all
the
right.
situation.
Only for that is.
Affidavit of service filed in court today is taken on record. Paragraph. Mr. Shivo Prasad Mukherjee, Learned Counsel, appears for the petitioner. Mr. Chundi Charan De, Learned Additional Government Pleader, appears for the respondents. The grievance of the petitioner in this writ petition is very limited. Poster. Referring to the application of the petitioners dated January 29, 2019 at page 50 to the writ petition, Mr. Mukherjee, Learned Counsel for the petitioner submits that on the said application, opportunity of hearing was granted to the petitioners as would be evident granted to the petitioner for the purpose of issuance of freehold title deed at Vijaygarh Squattle Colony. Vijaygarh Squattle Colony, SQUATTAL, Squattle Colony. Poster. The hearing notice is dated June 20, 2022, Annexure P4 at page 25 to the writ petition. Though the hearing has been concluded, but the reasoned decision has not yet been communicated to the petitioner for about last 2 years. Paragraph. In view of the above, Mr. De, which respondent, sir, has granted the hearing? Yes, petitioner. Which respondent granted the hearing?
Deputy Commissioner R, he's a party.
Bolo. Which respondent? Deputy Controller.
4.
Number
4. Respondent number 4.
ঠিক আছে, কি বললাম? The respondent number 4, who has concluded the hearing, is directed to communicate the reasoned order to the petitioners positively within a period of 4 weeks from the date of communication of this order. Paragraph. In the event the reasoned order goes in favor of the petitioner, all necessary and consequential steps shall be taken by which respondent, sir?
That
4.
Yes, madam.
By the respondent number 4 and or any other appropriate authority, positively within a further period of 4 weeks from the date of the said reasoned order, upon compliance of all the necessary formalities in accordance with law. Paragraph. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition, bold, WPA 12106 of 2024 stands disposed of, comma, without any order as to costs. Thank you.
And you're here for the petitioner. There is
But I'm for
but
the
an
respondent number 5, 6, and 7.
my lord, there is but an innocuous prayer, my lord. It's mostly against the private respondents, my lord. My lord, I have become the owner of a particular piece and parcel of property, my lord. My lord, this is a portion, my lord, measuring approximately 43 decimals and another 23 decimals, part of a larger property of approximately 355 decimals, my lord. My lord, the issue that has arisen, my lord, my lord, I have received this, my lord, by way of a gift from my husband, my lord. My lord, after this, my lord, the mutation was also carried out, my lord, finished, my lord, my mutation certificate, my lord, is dated 2nd of February 2023. My lord, after this, my lord, the petitioner, my lord, has realized that there are certain occupants, my lord, upon this property, my lord, being, my lord, mentioned,
Private respondents.
my lord, not just the private respondents, my lord, other occupants as well. My lord, the private respondents, my lord, are claiming to be certain members who have inherited the property or have received the property by way of, my lord, inheritance or purchase, my lord. But, my lord, even after purchase of the property, my lord,
the property has been gifted to you
lord,
by
not
your
just my-
husband.
my lord, the other portions of the property, my lord. My lord, the problem that has arisen, my lord, is that after the mutation certificate, even after the mutation, my lord, the property, the rights to the property, as well as the profits arising from the property, my lord, there being a pond where there is fishing activities carried out, my lord, the profits arising out of that, my lord, those have not been given to me at any point of time. My lord, in fact, my lord, I'm not being allowed access to that itself. My lord, in that case, my lord, this writ petition, my lord, I have filed, my lord, I had written a letter to the, my lord, the private respondents, my lord, wherein they have also spoken about an appeal filed against the mutation. My lord, the appeal, my lord, if my lord takes that
No,
letter,
1 second.
the reply.
Property has been this much of property.
See the prayer.
Sir, junior member, let's hear. Property is this much.
Yes.
For this much, you are the owner.
Yes.
Mutated in your favor.
Yes, ma'am.
Right? The balance, you are not the owner.
No, my lord.
Demarcation made.
No. There is no demarcation, my lord.
No demarcation. No demarcation.
So this is a Bali Khat, my lord.
Hmm?
This is a Bali Khat. Bali Khat.
Bali Khal.
Bali Khat.
But the sand has been
It's a-
excavated and it has.
It's become a pond.
So demarcation not possible.
No, my lord.
Demarcation not possible. What do you want? You basically want segregation of your property.
My lord, my
Share
lord,
of
I want access to my property at this point, my lord.
Access.
Yes, my lord.
But why your access is denied?
My lord, the fishing activities that are taking place in that said Wali Khat, my lord, the private respondents have been restricting my access to such. And my lord, even in a letter written to the,
That how a writ will be maintainable.
my lord, the issue.
I
my
was
lord,
thinking in a different manner. I was thinking if it is if it is
And
it can be segregated.
It can be segregated by filing one partition suit, because in pond, my lord, there are shares. Anas, my lord, has to be, my lord, declared by the civil court, but not
No,
by
I
the.
was thinking that if he has an exclusive ownership on a particular portion,
But in pond, my lord, that cannot.
that cannot be done.
So, my lord, he has to, my lord, file a suit before the
Civil
civil court, my lord. and
How do
opt
you?
that.
my lord, the only issue is, my lord, that the reply by the advocates for the private respondents had spoken of this appeal which had been preferred against my order of
Yes.
mutation, my lord.
He is contesting that.
My lord, the order of mutation happened in 2023. My lord, the
Even that.
said appeal
No,
is from
but
2022.
who filed that appeal?
We filed.
My lord, the private
Respondents filed appeal.
My lord, the appeal could not have been maintainable, my lord, since the order was, my lord, the order dated is from 2023, my lord, and the appeal which has been mentioned is from 2022. My lord,
Yes, that those points you take before the appellate authority, how the writ court will entertain.
my lord, at this point, my lord, the only protection, my lord, is that.
Acha, very well. Let us try to make the game easy. What do you want? Tell me. If it is permitted in the writ court or not.
My lord, my instruction, my lord, is that until the disposal rather of the writ petition, my lord, if I be allowed a share of the profits arising out of the property.
How can that be done unless your share is unless your share is determined by way of a partition suit? Unless your share is determined.
Yes, ma'am.
What share you claim, sir? 30%, 40%, 25%, 15%. How do I know?
My lord, if my lord comes to page 13, my lord, is the
13.
yes, my lord.
What's that?
My lord, that would be the
No, that is the yeah. Record of right.
yes, my lord.
Record of right does not confer any title. It's merely that you are paying the revenue. Record of right does not confer title. It's like mutation.
Yes.
Who is in possession? That's all. It does not confer any title. Record of right does not confer any title, Mr. Mitra.
এই চেয়ারটা নিলাম
বলুক ইয়ার বলছে বলুক
That is why I did not, my lord.
হাউস না দিলে তৈরি হবে কি করে?
Yes, my lord.
Record of right does not confer any title. It is merely a revenue
But I-
record that you are in possession, you are paying the khajna.
I understand, my lord. But my lord, this, my lord, is the my lord. If anything, my lord, shows that there is certain right accrued that has accrued in my favor.
Yeah, but it has to be adjudicated. To what extent, sir? What extent, sir? Do you claim 15% or 35% or 95%? How do I know, sir? A writ court will know. Unless you have a sealed adjudication on it.
I understand, my lord. I understand.
And record of right does not confer any title. It does never confer any title.
Very well, my lord. As my lord pleases, I will accordingly take steps accordingly.
Ashur. The writ petitioner claims recognition of her share in a particular chunk of land, which is classified as Bali Khad. With the specific description of land as mentioned in prayer A to the writ petition. Considering the nature of land and its users, demarcation of the property is not possible. Physical demarcation of property is not possible. Paragraph. Inasmuch as there is no conclusive evidence in the writ petition to show what is the quantum of share of the petitioner on the property. First paragraph. In view of the above, unless the share of the petitioner is specifically determined and quantified, no relief can be granted to the petitioner in the instant writ petition. Accordingly, this writ petition is dismissed, without any order as to cause. Paragraph. However, dismissal of this writ petition shall not preclude the petitioner to initiate appropriate civil action before the jurisdictional civil court to ascertain and determine his or her share in the property, and on the basis thereof, and on the basis of the adjudication by the final adjudication of the civil court, the petitioner shall claim her right, comma, if any.
Grateful.
So it is made clear that this court has not gone into the merits of the claim of the petitioner in any manner. And in the event any civil action is initiated by the petitioner before the jurisdictional civil court, comma, such civil action shall be proceeded in accordance with law, and the jurisdictional civil court shall not be influenced by any observation made by this court, and shall proceed with the civil action independently.
Grateful.
Paragraph, since affidavits are not called for, allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph,
Not the affidavit of service.
affidavit of service filed in court today is taken on record. I must grow up. Juniors must grow up. Thank you. আপনাদের give all your names.
My lord, we have given.
Sorry. Thank you.